Please, Lord. My Lord, item number 9, my Lord. We have challenged the rules in item number 9, my Lord. Perhaps it is a matter of division bench, my Lord.
Nine. Yes. Pass over.
No, my Lord, it is a matter of division bench, my Lord. We have challenged the rule in this matter, my
Okay,
Lord.
9. Okay. As rule isn't a challenge in this petition, the learned counsel for the petitioner submit that matter is required to be listed before the division bench. Most of the registry shall examine and place the matter before the appropriate bench.
Obliged.
Yeah, please, your Lordship. Lordship, I beg to mention item number 19, Lordship. I am for the respondent, Lordship, in this matter. We have filed to our affidavit in opposition. So kindly allow 2 weeks time, Lordship. Petitioner side is also present, Lordship.
You have filed?
No, not
You want to file?
want to file. 2 weeks time. Lordship.
Both sides are represented. List after 2 weeks so as to enable the respondents to file the affidavit in opposition in the matter. Any interim order is operated?
Interim order.
Extended.
Obliged. May I please, your Lordships, item number 20, Lordship.
Yes.
Adjourned today, Lordship. On the petitioner.
Okay. Both sides are represented on the prayer made by counsel for the petitioner. List after
4 weeks, Lordship.
4 weeks.
Interim shall continue.
Huh?
Interim is there, Lordship.
What is the interim then?
The eviction of the
No, then why you want?
Zaman- Zaman
why,
Matsui,
why you want an adjournment?
till that the government has no affidavit filed.
Instruction we have received. Instruction we have received.
Yes, in the meantime, I'll just wait for some time. Next.
Please, also. My lord, item number 18, my lord. There is
Yes.
some difficulty today, personal difficulty, my lord. Can it be next week, my lord?
You have informed the
I
other
am
side.
for, yes, my lord. Yeah, I don't
Query on
understand.
behalf of respondent number 4 and 5.
I am for the petitioner, my lord.
All sides are represented on the prayer made by learned counsel for the petitioner. List in the next week.
Yes, my lord.
Okay.
Obliged.
May I please, your Lordship. Item number 20, your Lordship.
28. Yes.
We have already sent our affidavit for vetting, your Lordship. Kindly.
You have informed the other side.
My lord, I am for the petitioner. My lord has sought a very specific instructions regarding a tentative date for elections. So perhaps a date may be fixed and it might be a little earlier than a week, my lord.
But
Any
you want
next week, my lord. Because the only question was for a tentative date of elections. And it has gone for its signature
Election
of the elections for the marketing board.
Chairman.
Very limited affidavit, my lord. Perhaps a fixed date next week, my lord.
Okay. Notice was issued on when?
My lord, notice was issued on 26/2/2024.
Okay. How much time you need?
1 week.
Both sides are represented. On the prayer made by learned counsel for the respondent. List on give a date after next week. Yes.
May I please, your lordship? Item number 27, lordship. I have filed an affidavit in reply. So, my lord, kindly call.
My lord, item 48, my lord. We had filed affidavit yesterday in compliance with the justice, and that may be called.
My please, Lordship. Lordship, I pray for listing of an eviction matter, Lordship. Obliged.
Yeah, please, Lordship. So in item number 15, Lordship, the government has filed an affidavit of opposition, Lordship. So I have to file a reply, Lordship. 1 week time may be granted, Lordship.
Okay. Both sides are represented. List after weeks so as to enable the learned counsel for the petitioner to file affidavit and reply in the matter.
Obliged, Lordship. Right, please, Lordship. Now I have taken the counsel of the other side, my lord. I beg to mention for item number 52, 53, and 54, my lord. I may be allowed to withdraw with liberty to file a fresh, my lord. There are some defects in the petition, my lord. I have also informed Mr. Kar and Mr. Chaudhary, my lord.
Okay. So why you want to leave to come again?
My lord, some statements are not properly made, my lord, in the petition actually. Yes, I went through if I found it, my lord. I have informed, my lord.
Mr. Arish Mishra and counsel for the petitioner seeks to withdraw this petition as there are some inadvertent errors and seeks leave to file again. Mr. S. C. Kerala, standing counsel for CGST, and Mr. B. Chaudhary Lanet, standing counsel for the state. GST are present. If prayer is allowed, understands dismiss on withdrawal with liberty to with liberty as paid for.
Deeply available.
Right, Mr. Lordship. I went to item number 36, madam. The earlier incumbent already transferred to other place, my lord. So we have to file implicit petition, madam. Kindly allow 2 weeks time to file.
Okay. The Grand Council for the petitioner submits that one of the respondents has been transferred and therefore pays for some time to take appropriate steps. Prayer is allowed. Matter stands adjourned today. This after
After
3 weeks.
Obliged. May I please, your lordship? Your lordship, with the consent of the other side, I would like to mention item number 30.
3-0.
30, yes, your honor. Yes, lordship.
Yes.
Your lordship, we have received the reply from the other side yesterday. And to that effect, we will be filing the rejoinder, your lordship.
Both
So,
sides are represented. Just after 2 weeks, so as to enable the council to the petitioner to file a given reply, you so advised.
so we seek for a date that is to be fixed on 13th of May, if it's convenient for the honorable court.
That is the.
Item 32. You know, I was allowed to file an affidavit, my lord, and I have filed yesterday. So there is not take with the file. With the affidavit may come on like Wednesday or Monday. Monday maybe.
Item number?
32.
Let the affidavit filed by the petitioner be tagged with the record. List on
8, 6.
8-5.
May it please your lordship. Item number 4040, my lord. May I pray the matter be adjourned for 3 weeks, my lord.
The prayer made there, this has been a counsel for the petitioner, list after 3 weeks.
Bless lordship.
Yes, so which item was that? 20.
Item 20.
See the draft of this here, my lord, we are sending for, so we are also sending. No one is sending, right, yet now.
Yes, left, I think. But what is it again?
Item, supply item 49 for withdrawal.
What is there? We don't come, we'll have to visit with the
Allow me to call him.
Yes.
After something. Okay.
Item 1 for motion.
May it please your lordship. My lord, the challenge before your lordship is the order passed by learned Joint Commissioner of Taxes in appeal, whereby my lord learned Joint Commissioner of Taxes has accepted the my lord other plea advanced by the petitioner as regard my lord unaccounted inward supply circular trading wrongful and unlawful ITC, except my lord ITC mismatch and remanded back the matter to the my lord concerned authority for calculation. That your lordship will find at page 103. And operative part, my lord, 132. Only in respect of one count, my lord, London Joint Commissioner of Taxes has not accepted the plea advanced by my lord petitioner and modified the order passed by appellate
But
court.
this has to go there, we can't interfere.
My lord, because my lord, tribunal, my lord, as per section 100, section 90, my lord, tribunal is required to be 109, my lord, constituted, but there is no tribunal. That's why I am before your lordship. Tribunal is not functional.
Yes,
Because it is yet to be determined, my lord. ITC amount has not been determined.
Lordship, at this stage, Lordship notice may go, Lordship, since tribunal is also not constituted, Lordship. Or Lordship may fix for instruction, Lordship.
you take it up on Monday then, get the instructions by then.
Lordship, can it be on Wednesday?
8, not my lord, except 8 any date, my lord.
Then it goes to 10.
10.
Okay. Mr. Eguel and counsel for the petitioner submits that the appellate tribunal is not functioning. The tribunal for GST disputes is not functioning. Mr. V. Chaudhary Leonard, standing counsel for the state GST, prays for some time to obtain instructions. Response 10/5/2024 as agreed to by both sides.
Deep.
Item. Time being item 49 for withdrawal.
Your pardon, lordship, I thought it was. Your instructions to withdraw this petition.
Mr. K. V. Pathak, Learned counsel for the petitioner. Upon instructions, therefore, from beginning to allow please for allowing to withdraw the petition. Mr. S. S. Roy Leonard, standing counsel for respondent of 5. You are for?
P. Bharadwaj, my lord, for respondent IOC.
P. Bharadwaj and standing counsel for the IOC. And Mr. H. Sharma Leonard, government advocate are present. Matters is different from the
Deeply obliged.
Item 2 with 3.
Sorry, my lord. Junior is also missing, brief is missing. Let me next week, my lord.
after some time, next day,
Next week.
next week, okay. Wednesday?
Yes.
What's the present? That's paid for by Mr. Artishan and Senior Counsel for the petitioner, based on 8/5/2024.
Those are the days, my lord, we used to reach at time. Time has changed.
Many old memories, good memories.
Item 4.
Your lordship, only for time being, lordship. Only for time being, lordship.
Timing,
Yes, sir.
just now.
Lordship, we have been directed to obtain instructions
Yes.
because of this ensuing Lok Sabha election, Lordship, they are praying for some time. So, Lordship, may give us some time, Lordship. They are praying for at least 1 month, Lordship.
Lordship, the immediate period.
Just now, just now,
Notification.
just now.
সময় লৈ আছো মই সময় লৈ আছো
Okay, we issue a notice then instead of keeping it in the motion and
Lordship,
your
lordship,
pendency of the repetition shall not be a bar.
lordship.
Okay, your name?
MSCM Decca Lordship. MSCM Decca Lordship. On behalf of Mr. R. Fukon Lordship.
Okay, your name, I still couldn't get it. Your name?
On behalf of Mr. R. Fukon Lordship.
Your name?
MSCM Decca Lordship.
CM Decca.
CM.
CM data. Then counsel for the petitioner and Mr. H. Sharma and additional senior government advocate appearing for the respondents.
Respondent number 2.
Oh, for one, Mr. B. Chaudhary. Planning counsel and H. Sharma for this one with issue notice returnable in 4 weeks. Requisite extra copy as the learned government advocate and the learned department council have accepted notice. Issuance of formal
Extra copy diba.
notices dispensed with. However, extra copies of the retribution be served on them in course of the day. Next part, the pendency of the retribution shall not be a bar.
Returnable 4 weeks.
For-
Extra copy diba. In the meantime, instructions.
Examining the claim of the petitioner and to reassess the compensation amount. And to release the same if found due. List after 4 weeks.
Item 5.
Please, your lordship. This is regarding victim compensation, my lord. We have challenged the impugned order, my lord, at base 42 and the another impugned, my lord, at base 46.
Where is that?
Base 42, my lord, the first impugned order. Actually, my lord, on 29/4/2019, the petitioner filed an application for victim compensation, my lord.
That was rejected.
That was rejected on 3/5/2019
Yes,
without issuing any notice, my lord.
yes.
And the impugned order was not furnished to the petitioner, my lord. Accordingly, my lord, the petitioner approached this honorable court, my lord, and this honorable court directed to dispose of the matter, my lord, if not dispose of, my lord, at phase 40, my lord. 39/40. Accordingly, my lord, case 40, my lord, the order
40.
40. The earlier order, my lord. Second paragraph, my lord, from the factual matrix narrated in the writ petition and the discussion of so and so the application for providing compensation under section 357A of the CRPC under the victim compensation is.
Okay, then what happened?
Then, my lord, the petitioner submitted application, my lord, on, my lord, 8/7/2020, page 46, my lord.
Yes, thereafter,
Then, on the body of the application, my lord, the secretary has rejected, my lord, in the top of the application, my lord, already disposed of. No further order needs to be passed.
okay,
Page 46, my lord.
then,
My lord, that order also not furnished to the petitioner, my lord.
yes,
Accordingly, my lord, we have filed an RTI application, my lord, in the year 2022, my lord. Serial number 12, my lord.
His number with, yeah.
Page 47, my lord.
yes,
That RTI application was rejected, my lord, stating that, my lord, the DLSA, secretary DLSA is not a public officer, my lord. Accordingly, filed an appeal, my lord, before the Asalsa, my lord. Subsequently, in the Asalsa passed an order. Accordingly, my lord, on 17/2/2024, the DLSA has furnished the impugned order, my lord.
after that, nothing has happened.
Nothing has happened.
This is DLSA of which place, Dhubri?
Yes, my lord. Dhubri, my lord. Page 42, my lord, the first impugned order.
Issue notice. Heard.
And the similarly situated matter, my lord, already disposed of page 49, my lord. I have annexed on similar order, my lord.
No, without issuance of notice, I'm not
Yes.
doing anything.
My lord.
I'm not disposing of matters in motion matters. Yes, I'm Hussain, counsel to the petitioner. Also, Mr. Ed Sharma and this additional senior government advocate appearing for respondent numbers.
1,
Three,
1,
3, 4, 5,
yes, lordship.
and Miss RM Barwal and it standing counsel for respondent number 2.
State authority, I mean, district 2. State Legal Service Authority, lordship, we cannot, the standing council is there.
For which respondent?
State, Assam State Legal Services Authority.
So number 3,
Yes,
Each of them within order is here. Standing council.
number 3. 3, more is the 1, 4, 5. 1, 2, 4, 5. 3,
yeah, I think. They have to serve copy upon them, lord.
The husband of the petitioner, namely Ismail Hussain, was allegedly murdered on 15/8/2010. Accordingly, Bilasipara PS case number 410/2010 was registered. However, by judgment and order dated 21/6/2017, passed by the learned additional session judge Bilasipara in sessions case number 129 of 2013, all the accused persons were acquitted. Full stop. The fear of the petitioner for victim compensation was rejected by the Secretary, District Legal Services Authority, Dhubri, by an order dated 3/5/2019. However, there's no order was communicated to the petitioner without, it's projected that without knowledge of the said order, the petitioner moved this court by filing WBC 1553 of 2020. And this court by order dated 13/3/2020, passed in WBC 153 of 2020, disposed of the said writ petition by directing the respondent by the Secretary Legal Services Authority, Legal Services Authority Dhuri, to dispose of the said application if not disposed. Full stop. When the copy of the said order was produced before the Secretary DLS Dhuri, the said authority made a note on the application about its disposal. Therefore, no, not therefore, as copies thereof was not furnished to the petitioner, he applied for copy of the order by submitting an RTI application, which was also rejected. Then how you got this copy of order?
My lord.
19?
Yes. By ITI, my lord. Subsequently, my lord, the assaults are directed to furnish the copy, my lord.
Where is that? You have not made a statement?
My lord, accordingly, my lord, the reply my lord at page 46.
56.
Here mention my lord reference Asalsa so and so dated 9 to 2024 at page 48.
Oh, okay. Subsequent RTI reply dated 17/2/2024. Copy of the said order was furnished to the petitioner. And according to this said rejection order dated 3/5/2019 in respect of prayer for victim compensation, which was passed by the Secretary DLSA, is assailed in this petition filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the replication be served on the learned State and Departmental Council appearing for respondent numbers 1, 2, 4, and 5. The petitioner shall take steps for service of notice on respondent number 3 by registered post with AD. So in addition, copy of the notice and the replication be served on the Mrs. R.S. Chaudhary, learned standing counsel for the State Legal Services Authority, Assam. And upon service and affidavit of service shall be filed prior to the next date of listing. Next paragraph. Pendency of this petition shall not be a bar for the Secretary DLSA Dhubri to examine the claim of the petitioner. List on. Give a date after 4 weeks.
Tenth of June.
10th of June.
Notice return of 10 June.
Item 6.
Item 6, my lord, the impugn order, my lord, page 76. This is third round litigation, my lord. In the earlier occasion, the petitioner approached this honorable twice, my lord. And this honorable court directed to pay compensation in terms of the notification, my lord, on to 2019.
Where is
But
that
the-
order?
Yes,
Where is that order?
my lord, first order, my lord, at page 56, my lord. And the operative part, my lord, at page 65, bottom. That being the position and following the decision of this court in Abdul Mannan Supra District Legal Service Authority, Dhubri is directed to take up the claim of the petitioner for victim compensation under section 357 CRPC, and after due inquiry decide the quantum of compensation to be awarded in terms of the government notification dated 1/2/2019. Then, my lord, the DLSA has provided only 1 lakh, my lord, at page 70. Page 70, my lord. As total compensation, my lord. 1, 2, 3. Paragraph number 3 and 4, my lord. Victim appeared and her statement on oath is taken. After due inquiry and verification, an amount of ₹1 lakh only is awarded to the victim as total quantum of compensation under so and so, my lord. Accordingly, my lord, again the petitioner approached this honorable court, my lord, at page 71. And the operative part, my lord, page 72, bottom, my lord. Keeping in view that there was a specific direction from this court in WC number 1563 of 2019 to consider the compensation under the government notification dated 1/2/2019. As agreed to by the learned counsel for the respondents, I do hereby dispose of this writ petition with a direction to the petitioner to file an appropriate application before the Secretary DLSA Dhubri for consideration of the case of the petitioner in the light of the order dated 30/4/2019 passed in WC number 1563 of 2019. The authority shall dispose of the application within a period of 30 days. Then, my lord, the petitioner filed the application on page 73, my lord. Thereafter, my lord, the impugned order, my lord, passed on page 76. In the bottom, my lord, stating that, my lord, there is no specific direction from this court, my lord. In the last paragraph, my lord, the Honorable Guwahati High Court has not specifically directed to award compensation of ₹5 lakhs to the petitioner, but directed this authority take up the claim, my lord. Although, my lord, this Honorable Court was directed
Where is that scheme?
scheme, my lord, 1/2/2019, my lord.
Where is that?
Page 25, my lord. Page 25, my lord, serial number 6, in case of death, my lord. Minimum is 5 lakhs and maximum is 5 lakhs. And the similarly situated matter, my lord, already disposed of by
No.
the other court, my
The
lord.
motion time, I'm not
Yes.
time that. You see, there are two reasons why I'm not
Yes,
looking at the previous orders.
my lord.
Number one, when you are looking at this scheme, please come to clause 7.
Yes.
There is a period of limitation prescribed.
Clause 7,
Second
my lord.
is, and second is clause 8 is appeal.
Yes.
And in fact, my lord, clause 5A.
My lord,
Five
clause
one.
7 is not applicable
Why?
because, my lord, the clause 7 is applicable only in respect of sections 370, 57A4, my lord. Where no trial comments and no offender was traced out, my lord. My lord, can to come to section 357A4, my lord. I am reading, my lord. Where the offender is not traced or identified but the victim is identified, and where no trial takes place, the victim or his dependents may make an application to the state or the district legal service authority for award of compensation. So, my lord, in this case, my lord, the trial already commenced, my lord, and the victim accused already convicted, my lord. So, section 357A4
Appeal 8, appeal.
and appeal B, section 8 also not applicable because, my lord, since there is a direction by this Honorable Court as well as the section 8 applicable only while in case of refusal, my lord. But in this case, my lord, part payment,
No,
1 lakh.
if your claim is rupees 10, they are
Yeah.
giving you 2. It's refusal to grant you 8.
But this is not a refusal, my lord. My lord, I am reading clause 8, my lord. Any victim aggrieved of the denial of compensation by the district legal service authority may file an appeal before the state legal service authority, my lord. But here, denial is not there, my lord, because they have provided only 1 lakh as a total compensation, my lord. My lord, my lord, page 70. The award passed by the DLSA, my lord. The awarded total amount of rupees 1 lakh. There is no denial, my lord. So, and there is a specific direction from this Honorable Court, my lord. And the impugned order passed, my lord, stating, my lord, there is no specific direction from the Honorable Guwahati High Court, my lord. So, my lord,
No, the specific direction for rupees 5 lakh.
yes, my lord. directed to pay in terms of
You're,
notification on to 2019, my lord. On to 2019,
where is that?
my lord, page 65. In the last paragraph, my lord. Last two line, my lord. Compensation to be awarded in terms of the government notification dated on to 2019 within a period of 2 months, my lord.
Okay, so they will have to. This case has to be allowed in the motion.
My lord.
And subsequently, again, that second litigation also, my lord, there is a specific direction, page 72. Paragraph 2, my lord. Keeping in view that there was a specific direction from this court in WBC number 1563 of 2019 to consider the compensation under the government notification dated on to 2019 as agreed to by the learned counsel for the respondents. Accordingly, the second writ petition also allowed, my lord.
Heard Mr. M. Hussain, learned counsel for the petitioner. You serve a copy to Mrs. R.S. Chaudhary and then come again, because otherwise it will be expired here. I will not be able to dispose it off.
My lord, maybe
Serve it to,
copy may be served by the clerk, my lord, but I don't know, my lord, why their name is.
no, those I don't know. If whether this there or not, you just give it and bring her here.
Yes, my lord.
Otherwise, you will not dispose it off. You have to issue notice.
Yes.
Expiry order I am not passing. Call her here. 7.
Wait, my lord. Notice, my lord.
No. You call her.
Ah,
Is
okay,
that
okay.
going to-
Serve a copy on her and call her here. We'll take it up at 2 o'clock.
Okay, my lord.
Yes, item 7.
The matter of this case is regarding shifting of a bus stand from Nagaon town area to outside the town area, madam. And on last occasion, Honorable Court directed the respondent to take instruction regarding the reason for which there is no shifting of the MS Sonai Valley bus stand from Nagaon town area to outside the town area, madam.
You got information?
Lordship, directive was given to the government council.
No,
I
my
have
lord,
produced the instruction on last occasion. The DTO has no rule in this matter, madam. Is that deputy commissioner has gone to start.
Instruction is
On last
awaited, my
occasion,
lord.
I have produced,
Communication has been sent on 24, my lord.
it's reflected in the last order also, madam.
Seventeen 4. Yes, we have it.
Madam.
Okay. Also, it's a represented. Mrs. M.D. Boral and standing counsel for the transport department submitted that the decision, if any, by the district commissioner on the shifting of bus stand in outside Nagaon town. Therefore, please for some time to obtain further instructions.
Lordship, the government will take instruction.
We have written letter, my lord. Communication has been sent, but instruction is yet to be received, my lord.
Okay.
Some more time may be granted, my lord. Or lordship may issue notice.
Yes.
In the meantime, we will respond, my lord.
Notice are not issued.
No, my lord. To my knowledge, notice is not issued.
Okay.
Notice was
Only
Okay.
fixed for only obtaining instruction, my lord.
Okay. You are Mr. P.K. Mazumdar. Mr. P.K. Mazumdar, counsel for the petitioner. Issue notice returnable in 4 weeks.
My
Yes. And Burman, and government advocate that accepts notice for on behalf of respondent number
3 and 4, my lord.
3 and 4. And Mrs. M.D. Bora would be for 1 and
3, 4, 5.
1, 2, and 7, Lordship, I am.
1, 2, and 7.
Madam.
So you will be for 3, 4, 5.
5. Corporation.
3, 4, 5. 6 also.
6, my lord.
3, 4, 5, 6.
8, they have to take steps.
Therefore, issuance of notice formal notice on them are he is exempted. So however, requisite extra copies of the requisition will be served on them in course of the day. Next one, the petitioner shall take steps for service of notice on respond number 8 by registered post PDD. So notice is made returnable on so and so. Next one, the learned government advocate as well as the learned standing counsel for the transport department are obtaining instructions subsequent to communication dated 17/4/2024 received by the learned standing counsel for the transport department.
Communication of complaints.
Item 8,
Obviously.
That's it. Ready.
Our last location, Lordship, the
Button on your
direction
port.
was
Button up your port.
put. Lordship, I lost the button there in the. Okay.
We'll ask the officer in charge of Dovoka Police Station
Milo.
to produce the general diary for the court in original.
As they have negated, no complaint is received.
Because the Superintendent of Police does not even refer to a GD entry. How can a preliminary inquiry be conducted without a general diary entry?
My lord.
Your name?
S. Ahmed.
Ms. S. Ahmed, and constituted the petitioner is present. Ms. M. Burman and Granite Advocate has produced a copy of. I'm sorry, pursuant to order dated 8/4/2024, is M. Burman and Government Advocate has produced a copy of instructions dated 2/5/2024 received from the Superintendent of Police Hojai. First of all, the next part, the officer in charge of Doboka Police Station shall reduce the original record of general diary entry general diary of the said police station from 10/5/2022, sorry, 1/5/2022 to 31/8/2022, and for the month of 1/2/2024 to 30/2/2024. Next one. The officer in charge of Doboka Police Station shall ensure that the police personnel from his police station produces the original general diary of the said police station, the aforementioned dates, at 10:50 AM on 2/05/2024. Next, the London Government Advocate shall send a downloaded copy of this order to the Superintendent of Police, Hojai, as well as to the officer in charge of Doboka Police Station through VHF facility available in the court. List on 2/05/2024.
Problem.
Item 10.
Mid loss. Here, my lord, what happened? Sometime 1988-89, my lord. The railways initiated the proceeding under section 4 and 5 of the public premises.
Initial notice here.
My lord,
Initial notice here.
yes.
Mr. R.P. Chandra, Senior Counselor. for the petitioner, assisted by Ms. A. Deca, counsel for the petitioner. Also heard Mr. M.R. Adhikari Leonard. CGC appearing for respondent numbers
1 to 5 and 7.
1 to 5 and 7. And Ms. M. Burman and government advocate appearing for respondent number 8.
1 to 5 and 7.
6 also you can appear.
Yes.
He's been made party by name, my lord.
Anyway.
Yes.
It's projected that by an appellate order dated 27/5/1994, passed by the District Judge Dibrugarh in Miss Appeal number 8 of 1993, by which order passed under Section 4 of the Public Premises within bracket eviction of unauthorized occupants bracket closed Act 1971 was set aside. The direction to proceed de novo from the stage of notice. Stop. It is alleged that de novo proceedings was never held for last 27 years. And on which date you were evicted?
2021, my lord, month of August.
It was on 10/8/2021. 10th of August 2020.
10/8/2021. But 10/8/2021, the petitioner is not, he has not pleaded that date.
He is not given the date, but I have the instructions, madam.
Yes.
Yeah, today morning I received one.
No, you give that here. We are not, when the petitioner is not saying that.
2021, August 2021.
No, you have not stated anywhere.
2021 only we have stated because he
Year 2021.
has forgot the date.
The petitioner has approached this court by filing this writ petition seeking compensation.
And for joint survey, my lord.
No, that can't be done in a writ petition because I was intending to close this writ petition because if you are seeking a compensation, you will have to oppose the.
No, compensation part I am not pressing for my lord. I am pressing for joint survey, whose land, because my claim is.
We will not allow that. In a writ petition, we will not allow you to create a evidence which shall not be used in a writ petition. Because if you are filing a suit for compensation, you have to oppose the civil court.
No,
And
I am
civil
not
court-
saying your compensation now, I think.
No, but you can't get you see, assessment made now. Will be a never ending task.
But
for the
I am
court.
on my lord, without joint survey, in spite of regular continuous demand for joint survey, because it is government land and nearby there is Hindi high school. Since 80s, and just adjacent there, the Hindi high school also filed a case
No,
against
you
us.
see, under the principles of compensation.
My lord, I am saying the
It's okay, but-
compensation, not the
what
issue
is the
here.
purpose of this? You see,
I
there
have
must be
said
some
simply
purpose.
manner because they compare without notice, without anything, my entire, even TV sets, cars,
So that's
wedding
okay.
apparels,
That's
everything
okay,
was
we
destroyed.
can have sympathy, but you see, the issue is something else. The issue is that that an order without a declaration, only to give only to elicit a joint survey report. That's not the court.
Even for the land, we have taken up a position of the land also.
226, we can't do that.
My lord, Courts have been giving my joint survey. There is under the rate jurisdiction, man. So far I know because even railway alignment in this Nunmati area, joint survey is ordered by this court. In Maligaon also.
You see, please
All
justify
that-
the.
It is not beyond the jurisdiction of the deed.
No, no.
Joint survey can be ordered.
What is the fundamental right to have a land, what do you call a joint survey made?
My lord, if it is the not the railway land, government of Assam has not taken any decision. My lord,
Let us
in
say they do it,
government
it
land,
is
there is
illegal to-
tag number given.
Mr. Sharma,
Yes.
you see, limitation cannot be extended. If you have to approach the civil court, your limitation is otherwise gone. That's why I asked you that, I started with that question. You now still have, if it is August, I did not want to record in my order only for that reason. If you are in August, you still have 2 months time to approach the civil court. After that, it will be time bound.
That, well, my client will say, at least a lots of notice.
No, no, no. This will be closed. We can't create a evidence at this stage by a writ petition.
My lord, the courts are giving, say, then let it fix next week. I'll argue.
Okay.
Let it fix next week.
Okay.
Because number of cases I have
No, maybe there may be hundreds of orders. but
without joint
you
survey,
have
when
to
it-
show that it's a
unless
binding
the
step.
railway acceptance of whose land it is,
Sharma.
can the railway,
Okay,
because,
when you are-
because they have the power, they can evict.
It's okay.
Then what-
You are making a motion on Monday, you will make it on Monday. We'll put it on
Maybe
Monday.
Wednesday, madam.
Wednesday.
Wednesday, madam.
Wednesday, okay. This one. Wednesday. As paid for by Mr. Afi Sharma and counsel, senior counsel for the petitioner.
All right.
Supply item 50.
May I question? You also says directed to make a corridor, whether it's a non-profit organization relating to my lord. My lord, the petitioner has no tree processing unit, my lord, only producing the green leaf, my lord. The petitioner prepared a short note, my lord. May I? read it?
Number present. 4 weeks.
Which page was the impugned order?
Annexure J, my lord, page 178, my lord.
78.
The second paragraph is important, Lord.
What is your statement of the writ petition regarding tea cultivation?
Tea cultivation, my lord, my statement specially mentioned, my lord, that this land is specially exclusively used for tea cultivation, my lord.
Where is that?
Hmm? My lord. Paragraph 10, my lord. Page 12, my lord. The petitioner
expressed that the petitioner regularly maintaining tea cultivation in the land mentioned by the Deputy District Commissioner, Kamrup Metro, Guwahati, for which petitioner reported necessary contribution with the tea employee provident fund. The petitioner also made contribute labor welfare fund also, my lord. Deputy labor payment register also, my lord. And my lord, paragraph 9, tea petitioners is registered with Tea Board of India also, my lord, specifically, my lord. One certificate also given, my annexure KLNM, my lord. And photograph also, my lord. Page 11, my lord, paragraph 9, my lord. Paragraph 9, page 11.
Mr. Sharma, you're issuing notice, he's making a statement that
The
notice was
today
not
my
heard.
learned friend has provided this, but here lordship nowhere is stated that they are also engaged in.
Second,
That's a over.
especially
Lord,
mentioned, there is no industry, my lord. No tree processing, only producing the green leaf, my lord, by local labor
Now
of 40
there,
to 50 kilo, my lord.
The main trust area of the Don Bosco Society Azara are educational and social. But even the lordship let me notice. And lordship, in the meantime, may I suggest lordship? The representation which they have filed, there is no bar in, dependency shall not be a bar in disposing that. As because they have narrated everything there specifically.
No, you see, that's one part. The second part is he's making an allegation that mandatory notice before taking
Lordship.
steps under 4.2 was not said. In the
Yes,
order,
I have also seen it is issued to the university, not to the society. That notice was issued to the university, but even then, lordship, it's a part.
it's okay, but it's a, It's a relevant issue. Notice must be served to the affected person only.
Lordship.
But Mr. Saikial and counsel for the petitioner. Also heard.
I am for
Mr.
two and
P.M.
three.
Leonard, Leonard, standing counsel for the respondent number 1. And Mr. H. Sharma, the government, additional senior government advocate appearing for respondent number 2 and 3. You can't make your respondent number. Oh, you can't array the respondent number 4 as respondent number 4. Your interest and their interests are same. You juxtapose it, you transport in to a petitioner. This is a T state, and
Lordship.
this statement is here that the Don Bosco Society is the owner of that T state, right?
My lord.
So once you are the owner, you can't have that same your own part as the respondent. You can't fight with yourself. Having at the outset, having noted that the petitioner society claims to be the owner of no. Also, no. The petitioner shall take steps for service or notice on responding. No, for say, by filing this petition under Article 226 of the Constitution of India, the petitioner has assailed order dated 11/3/2024, issued by the District Commissioner Kamrup Metro Guwahati, thereby power under Section 4 within bracket 2 of the Assam Fixation of Ceiling on Land Holding Act, 1956 was invoked. An order was passed for resumption of the scheduled land as ceiling surplus land. The direction to the circle officer, Sonapur Revenue Circle, to correct the land records. You should notice returnable in your fixed date. 5 weeks. Returnable on so and so. Is the trade respondents. Respondent numbers 1, 2, and 3 are represented, comma, issuance of formal notice is dispensed with. Our extra copies of the replication be served on them in course of the day. Next one, the petitioner shall take steps for service of notice on respondent number 4 by registered post with AD. Full stop. Next one, as an interim measure until the next returnable date, comma, status quo in respect of the land of the Pepsia Tea Estate as on 3/5/2024 shall be maintained.
Lordship.
Land of Pepsia Tea Estate
My lord.
shall be maintained. Okay.
12th of June.
Much pleasure.
Item 51.
Here in this case, my lord, the petitioner is running a restriction issue for the last 12 years.
Yes, just a minute.
We have been directed to obtain instructions, Lord.
Just 1 minute. Yes.
Yeah.
Okay.
I am placing it before your lordship. Ekhon lobo na. Paragraph 3. Now, now your lordships,
Mr. Islam, they have denied that they have allotted you land. They say that you have made illegal construction. You were evicted from one part, then you went to the other part, and then you started your shop again.
and your lordships may kindly come to paragraph 4 of their writ petition. Paragraph 4 at page 7. Has your lordships got it?
Yes.
They have here they from 4th line, lordship. The circle officer Mankasar Revenue Circle made a spot inquiry and allotted a plot of land to the petitioner at a deep pit near the office of the District Commissioner Hatsingimari by demarcating the land for the purpose of the establishment of the petitioner's shop. Thereafter, the petitioner filled art and developed the allotted land and constructed one shop, more spending about rupees 2 lakhs, and the petitioner is running the shop at the new that has been denied in our reply. Now your lordships may kindly come to page 12 of the writ petition. They have made this paragraph 4 as a matter of record. Let him prove, lordship, that is a matter of record. In the affidavit, lordship, they have made it as a matter of record.
My lord, below of the para 4, my lord, there is a medical document, my lord. That medical document is part of the, my lord, record, my lord.
So everything is part of the record. The whole paragraph is a part of the record. This land allotment made by the circle officer is a part of the record.
My lord, for the last, the first notice, my lord, the eviction notice, my lord. The eviction notice was issued, my lord, without issuing any prior show cause notice, my lord. I complied with the,
That part has already gone, lordship.
I complied with the notice, my lord. Only for the purpose of the road was, my lord, the land was required for the public purpose.
The whole thing is
For
an
expansion of the
afterthought,
public road,
lordship.
my lord.
The whole thing is an afterthought. They have again constructed.
Yes, my lord.
Now they have come to,
That is-
by narrating the whole
That is
story in
admitted,
paragraph
this is-
4.
this is-
Just one, just one. If Islam is a roadside land, if you don't have any authority to be there, we can't protect you.
No, my lord, my only submission is that, my lord, at this is, my lord, the land where my shop is situated, my lord, it is even not required for the expansion of road also. Because after expansion of the road, my lord, this shop has been, my lord, established, my lord. And secondly, my lord, on the basis of a representation, my lord, Lord Mandal and some revenue official came from the circle office and, my lord, allowed me, my lord, selected the area, my lord, and allowed me to construct the shop, my lord. Only
Matter
on
of
that-
record, lordship, according to him.
They may deny, that is another thing, but otherwise, my lord,
It's
on the-
okay, you see, we don't know this name of the persons who have come there. You could have fixed a personal liability to those persons who have permitted you to,
then lordship may make a direction for enquiry, my lord.
no inquiry. You don't give names of people, how can we?
Otherwise, my lord, the petitioner is also entitled to the right to life, my lord, under Article 21, since this is the only source of our livelihood. And secondly, my lord, this, even the area where my shop is situated, it is not required for public purpose. They will have to show whether if this is my unauthorized, my lord, occupation, my lord, at least they will have to show that this is the unauthorized occupation and this area or this land is required for in public purpose. For public purpose, they require the land, my lord. They will have to again issue the show cause notice, my lord. Without issuing any show cause notice,
Under which law? Under which law?
my lord.
Under which law?
My lord, this is under the, my lord, PP Act, my lord. The Public Claims Eviction Unauthorized Act also, that law also says the same thing. And this also the law of national justice, my lord. That I'm entitled to, my lord, a show cause notice, my lord. They have come with a bulldozer to demolish my shop.
You have seen the definition of public premises,
My lord, I want to place on judgment. That judgment is particularly on the law of national justice, my lord.
Yes.
My lord,
public
placing three judgment, my lord. And all the judgments are related to, my lord. One is promissory estoppel, and the another is, my lord, with regard to national justice, that I am entitled to show cause notice, my lord. Lordship will find the first judgment, my lord. Three judgments are given here. The government of Mysore and others versus J.B. Bhatt and others, my lord. Here in this case, it's a very old 1974 judgment. Para 4, my lord. That the Honorable Supreme Court, my lord, cited Binapan in this case and held the rule that a party to whose prejudice and order is intended to be passed is entitled to a hearing applies alike to judicial tribunal and bodies of person invested with authority to adjudicate upon matters involving civil consequences. It is one of the fundamental rules of our constitutional setup that every citizen is protected against exercise of arbitrary authority by the state or its officers. Duty to act judicially would therefore arise from the very nature of the function intended to be performed. It need not be superadded. If there is power to decide and determine to the prejudice of a person, duty to act judicially is implicit in the exercise of such power. If the essentials of justice be ignored and an order to the prejudice of a person is made, the order is a nullity. That is a basic concept of the rule of law, and importance thereof transcend the significance of a decision in any particular case. So here also, my lord, I am entitled to a, my lord, hearing, my lord. At least my lord, the show cause notice, my lord, so that I can make my lord, reply to the authorities, my lord. Second, my lord, the second decision
This is my lord, state of Uttar Pradesh versus Maharaja Dharmendra Prasad, particularly law portion. Lucknow Development Authority versus my lord V. Maharani Raj Lakshmi Kumari Devi and others, my lord. Here, para 15, my lord says, para 15 of the judgment, my lord. I have highlighted the some portion, my lord, the middle portion. A lessor with the base of title has no right to resume position extrajudicially by use of force from a leasee, even after the expiry or earlier termination of the lease by forfeiture or otherwise. The use of the expression re-entry in the lease deed does not authorize extrajudicial method to resume position. Under law, the position of a leasee even after the expiry or its earlier termination is juridical position and forcible disposition is prohibited. A leasee cannot be dispossessed otherwise than in due course of law. In the present case, the fact that the lessor is the state does not place it in any higher or better position. On the contrary, it is under an additional inhibition stemming from the requirement that all action of the government and governmental authorities should have a legal pedigree. In Bishandas and others versus the state of Punjab and others, this court said, we must therefore repeal the argument based on the contention that the petitioners were trespassers and could be removed by an executive order. The argument is not only specious but highly dangerous by reason of its implication and impact on the law and order. Before we part with this case, we feel it our duty to say that the executive action taken in this case by the state and its officers is destructive of the basic principles of the rule of law. Therefore, there is no question in the present case of the government thinking of appropriating to itself an extrajudicial right of re-entry. Position can be resumed by government only in a manner known to or recognized by law. It cannot resume position otherwise than in accordance with law. Government is accordingly prohibited from taking position otherwise than in due course of law.
Mr. Rajabhi, I think you will have that. The division bench judgment on 18-2.
My lord, I have the judgment now, it is under, because my.
I am aware of it, but what is the judgment? You are aware of it?
My lord, 18-2 that presently it has been referred to as your lordship.
I am aware of it.
My lord, I am appealing there. Now there is a.
That's why I have asked you.
There is a question arising thereupon, because.
I am aware of all those. I just wanted that 18-2 judgment of division bench.
No, it has not come.
Huh?
It is fixed on 16.
No. There is already a judgment. That's why reference is made.
Because the one is 2006 3 GLR page 99. That is
2000?
That's 2006 3 GLR page 99. Single judges benches. And
Yes.
another is my lord 2018 1 GLR page 30.
30.
30.
30.
One has said that notice is required, another has said
Notice is not required. That is by reference.
that was reference. That is two judgments, sir.
Yes, I am aware of it.
Your lordship was referred. Your lordship was referred that.
I am aware of it. That's why. But I know that you remember citations here. I don't remember it here.
We do one cases, but your lordship does 100 cases. That is the difference.
My lord, actually, what is the problem coming up, my lord? So for my verbal instruction from my petitioners. Actually, after demolition of the shops, my lord, on the roadside, the petitioner was allowed by the authorities to construct her shop, my lord. Subsequently, my lord, after construction of the shop by the petitioners, the other shopkeeper, my lord, who were also, my lord, standing on the roadside and they vacated the shop, my lord, they also, my lord, is to make the same demand from the authorities. Only then, due to pressure from the other shopkeeper, my lord, they are taking this decision to, my lord, remove my shop, my lord. This is the actual fact, my lord. Otherwise, in my writ petition also, I have made the statement that the authorities came, my lord, they selected the plot, my lord, and they have allowed me to construct the shop, my lord. And otherwise also, my lord, I am entitled to a, my lord, natural justice, my lord. I am entitled to show cause notice, my lord. Without show cause notice, my lord, they cannot come with bulldozer and, my lord, remove me, my lord. That is my case, my lord.
But Mr. M.A. Islam and counsel for the petitioner and Mr. H. Sharma, an additional senior government advocate appearing for the respondent number 2 and 3, and this PR non-third and standing counsel for the revenue department appearing for respondent number 1. Case projected by the petitioner is that she is running a stationery shop at a location opposite to the office of the district commissioner South Salmara Mankachar, Hatsingi Mari, since 2012. Full stop. The petitioner was served with a eviction notice dated 3/2/2024 by the circle officer, Mankachar Revenue Circle, for eviction of the roadside shops for the purpose of expansion of Hatsingimari Mankachar Road. Full stop. The petitioner submitted representation dated 5/2/2024 and 6/2/2024 to the district commissioner South Salmara Mankachar and to the circle officer, Mankachar Revenue Circle, for allotment of a suitable plot of land to establish her stationery shop. Full stop. It is projected that the land revenue staff of the circle officer, Mankachar Revenue Circle, allotted a small plot of land to the petitioner near the office of the district commissioner Hatsingimari after demarcating the land, whereupon the petitioner had constructed a shop by spending a substantial amount of money however.
Your Lordship permits me to say one thing. My Lord, Rule 23, Assam Land and Revenue Regulation states, nothing in this rule shall entitle any person to obtain a lease in respect of a land within 35 feet of the central line of a public.
We are aware of it.
My Lord, that is, my Lord, if it is a roadside land, what I have learned.
Yes, yes, I am aware of it.
Sorry that I am.
No. Definitely, you have, what you call, you've done well by reminding us,
Rule 23.
because I'm aware of it.
Sorry.
No. I'm, in fact, I'm delighted that you have, what you call, you have told us. No question of sorry. We are delighted, in fact, to have your assistance. First, however, on 25/4/2024, the officials from the circle officer, Mankachar Revenue Circle, came with bulldozers and attempted to demolish the shop of the petitioner. Full stop. Next, the learned counsel for the petitioner submits that the petitioner was entitled to a fresh notice before making any attempt to evict her from the shop. So it is submitted that the right of being heard and to provide natural justice is an ingrained facet of the Constitution of India. So it is also submitted that the respondent authorities must first establish that the land was required for any public purpose, and only thereafter by compliance with the requirement of issuance of prior notice under the public premises within bracket eviction of unauthorized occupants bracket was Act 1971, comma, any further steps could have been taken. Next part, in support of his submissions, comma, the learned counsel for the petitioner has cited the following three cases. These three. Next part. The learned additional senior government advocate, comma, pursuant to order passed on 1/5/2024, has produced instructions dated 2/5/2024 received from the additional district commissioner, comma, South Salmara Mankachar, whereby it is denied that the petitioner was allotted any land for the shop, and it is specifically stated that after the petitioner was evicted from the original place of her shop, comma, she had constructed shop on the other side of the road illegally. Next one. At the outset, it would be appropriate to refer to the provisions of public premises within bracket eviction of unauthorized occupants, bracket close Act 1971, as it is deal with the three case laws cited by the learned counsel for the petitioner. Full stop. Public premises is defined under Section 2 within bracket E of the 1971 Act. Full stop. The said provision is quoted below. It will be 2E, then 1(2). Oh. One, two, and four. Is it long, huh? 1, 2, and 4.
Section 4.
When 4 ends, you'll find F top till there. Till 4. Full stop. Therefore, from the above, there is no doubt that a road would not come within the definition of a public premises. A road or roadside land would not be covered by the definition of public premises. Next paragraph. In the case of Century Spinning and Manufacturing Company Limited and another within bracket Supra, the said case related to enforcing the provisions of the Maharashtra Municipal Act, the Municipalities Act 1965 relating to levy assessment, collection and recovery of octroi. Full stop. It is in the said context that the decision was passed by observing that the public bodies are as much bound as private individuals to carry out representations of fact and promises made by them. Full stop. In this present case in hand, there is no record of the district administration or any representatives under it of having allotted a roadside land to the petitioner for setting up a shop. So therefore, it cannot be accepted that a promise was made by the respondent authorities in allotment of land for setting up and allegedly for setting up a shop. Full stop. If any such allotment was made, that would be expressly illegal, as the settlement of land is within the jurisdiction of the state government, and all such actions are to be taken in the name of the governor. Full stop. Under the Assam Municipal Act, 1956. No, not too bad. In the case of the government of Mysore within bracket Supra, a reference to the case of Binapani Dei, Binapani, the DEI, was this will be Binapani Dei versus State of Orissa versus
Binapani.
Dr. within bracket Miss Binapani Dei and others.
Yeah, 1967.
AI 1967, SC 1269. Wherein observation was made that the rule that a party to whose prejudice an order is intended to be passed is entitled to a hearing applies alike to judicial tribunals and bodies or persons invested with authority to adjudicate upon matters involving civil consequences. Full stop. No doubt that a citizen is protected from arbitrary authority of the state, authority or action of the state. However, comma, in this case in hand, comma, there is an admission on record that the petitioner was served with a notice for eviction, and the petitioner had merely shifted the shop to a new location within the vicinity of the office of the district commissioner. Full stop. Therefore, if there is a repeated encroachment of a government land, comma, the court is of the considered opinion that a fresh proceedings or a notice and a notice for eviction would not be required for the in such cases. Full stop. Party who has been evicted, a person who has been evicted by exercise of power of the state by issuing notice cannot be permitted to make a fresh enforcement and insist on such procedure being adopted again. Stop. Therefore, the said case also does not, the said case of government of Mysore, Olympic Supra, also does not help the petitioner in any manner. Next, with regard to the case of state of Uttar Pradesh and others within the Supra,
1989 2 SEC 505.
no, so we already have that. In this case, comma, the state government had granted lease to the affected persons, and thereafter the leases were cancelled by the state government. Full stop. In the said context, the Supreme Court of India had observed that lessor has no right to resume possession extrajudicially by use of force. Full stop. The said principle will not apply in the present case in hand, where the petitioner has not been able to demonstrate that he is a lawful lessee in respect of the land where the shop of the petitioner is located. So therefore, the said case also does not help the petitioner in any manner. Next one. Next, the petitioner has not been able to show any vested right to have a allotment of the roadside land. Full stop. It will be, it cannot be accepted that if roadside land is encroached, comma, the government would not be able, the appropriate government would not be able to evict the encroacher after issuance of notice, which was done in this case, and it is the admitted case of the petitioner that after being issued with a notice of eviction, comma, he has changed the site of the shop. So we have already held that once a notice of eviction was issued, and thereafter if the site is altered, eviction would be the eviction of the eviction process against the petitioner would not be bad in law. Therefore, comma, the court does not find this to be a fit case to entertain the writ petition, which would have the effect of permitting encroachment of the roadside land by the petitioner, to which she has no fundamental right or any enforceable right. Next, but according to comma, this represents since dismissed at the motion stage without issuance of notice on the respondents. Can take a break and come back.
All right.
Lord projected this case for Lord compensation due to the death of her daughter. Now, Lord, the police report lordship will find at page 49 in the writ petition, Lord. Page 49 is the Lord police report. Yes, Lord, we have annexed, Lord, in the additional affidavit, lordship will find at page, Lord, 56, Lord, in the additional affidavit filed by the petitioner. Page 56. There, lordship will find, Lord, column number 3. Ex gratia to the NOK of person killed due to accident in public places or in public careers other than killed by the extremist, terrorist, miscreants, and due to the firing of the security forces. That is. Our FIR lordship will find that is at page 38, my lord. 38, 38.
Well, the doctor is right because of this,
So they try to bring it accident in public place, madam. They have annexed one judgment, madam. I cannot say there is a gray area, but since these are not challenged by the state. My
because it's the
difficulty-
accident. Despite we seen in the Black's Law Dictionary. The meaning of Black's Law Dictionary of accident is an unintended and unforeseen injurious occurrence. Something that does not occur in the usual course of events, or that could not be reasonably anticipated.
So that way, my lord, it comes under the ambit of accident, but that is accidental. But whether during the course of flood or natural disaster or in a normal
So,
condition.
but you see, we must understand the law from the text of your notification only.
Well,
In that notification, you don't. I'm sorry, I forgot. In your notification, you don't distinguish between these two. You
Yeah.
don't even say that, let us say this, she's a 13-year-old girl, gone for a bath in a nala
and drowned.
and drowned.
Right.
You don't even say that the facilities for which the government has schemes are being operated. Like, for example, you must have the toilets and all, or for all that you are giving money. Even in the panchayat area, even in the village area, you are mandatorily requiring that there should be a public bathroom or those things should be there. So you don't restrict your the clause of compensation with any negative clause. You say accident, you take money.
Any
Any accident.
there is no further explanation. That is, my lord.
There's no further explanation. So it's the wisdom of the government, we have to respect it.
And that ties my hand also. I cannot make.
Huh?
That ties my hands also. I cannot
Yes,
make any
yes.
submission.
So allow this writ petition. Yes, yes.
That the definition of disaster is saying. But that has been explained in this judgment.
No, you see this, you come to your notification.
Annexure 1, ma'am. Same under SDRF.
It's 56. Petition level.
No, not this. The
56.
1511.
Where is this 27/7/2011 is this SDRF? Okay, what is the definition?
Cross three, my lord, that SDRF shall be used only for meeting the expenditure for providing immediate relief to the victims of cyclones, drought, earthquake, fire, flood, tsunami, hailstorm, landslide, avalanches, wood blast and pest attack, my lord. Under this notification, my lord.
No, then you have to withdraw this reparation and you have to come again. Your
His
company
claim was-
can't be under from SDRF fund. It
Yes.
can't be.
That is Mulata.
Part of this, my lord.
Mulata, that is why Mulata, we have filed Mulata additional FDP.
No, you have to amend it. Either you file a full-page amendment because you can't have the prayer of 27/7/8/85 and 25. We permit you to file a fresh petition. Or amend this if you want to.
And the part is fell down.
Because Mr. Mandal, I have my own doubts whether by way of an affidavit, you can improve your writ petition. I have my doubts. Either you amend it or
We'll file a fresh Mulata with liberty.
we will permit you to do it.
That part is
Hearing next week, right?
not a disaster, my lord.
Pardon me? Hearing, no?
Bath
Okay.
fell down to the water is not a disaster, my lord.
No, it may not be a disaster, you are correct. But it is otherwise covered by your notification. Revenue, what do you call this?
15/11 to
15/11/2014, is covered by that.
SDRF
It's okay, that's why that did not strike me earlier. Mr. M.E. Mandal and counsel for the petitioner. Also heard. CGC will be appearing. Your name? K. Kalita. Learned counsel appearing on behalf of Mr. K. Parashar, CGC, for respondent number 1. Mr. B.G. Talukdar and senior counsel. Assisted by Mr. P.K. Mehdi and the government advocate appearing for respondent number 2, 5, and 6. Mrs. P.R. Mohanty and standing counsel for the revenue department appearing for respondent number 3. And finance will be there, Mr. Chalia.
Therefore,
Huh?
I'll inform you.
Okay, Mr. A. Chalia, and standing counsel for the finance department appearing for respondent number 4. Next part. The prayer in this repetition is to avoid compensation to the petitioner for the death of his minor daughter under the National Disaster Response Fund. Full stop. However, the learned counsel for the petitioner has submitted that by filing an additional affidavit, he has got on record notification dated 15/11/2014 issued by the Revenue and Disaster Management Department, entitling the petitioner to compensation. Full stop. As the court is not inclined to accept an affidavit to constitute amendment of the pleadings in a writ petition, the learned counsel for the petitioner please to allow him to withdraw this petition and to approach again. Full stop. The said period is allowed. This writ petition stands closed on withdrawal. Going to in a defect in this petition. Stop. However, the petitioner is granted liberty to approach the court again with an appropriate clearance. Mr. Wonder, we are permitting it.
Developers.
But we can also permit you to amend it, whatever you like. Both options are offered, because 13-year girl has died here, not on manner, but do it.
Obliged.
Item 13 with 14.
My lord, I will request your lordship to take up item number 14. Both are same.
Okay, just a moment, Mr. Azhar, you are there. How is the health of Dr. Ahmed?
Now it's okay, my lord. Now it's okay.
Now is okay.
Only eye problem.
Eye problem is there, he cannot.
Item 14.
14. 13 and 14 are same. Item 14, WPC 6283.
Yes.
My lord, I will take you directly to page 99. These are against all this show cause notice that we have come before this
Ancient monuments.
Ancient Monuments Act of 1958.
How do you say that you are outside the periphery of the prohibited area?
My lord, that is our statement, but one thing that my submission will be, my lord, I had a sale deed and a patta land from 1956. Prior to the act came into force of 1958. There is a provision under the act, section 20, which says if you want to take that particular plot of land under this act as a public purpose, that you have to acquire through Land Acquisition Act. And that was denied by them in their affidavit. They say there is nothing like such provision. But I have annexed the act, my lord, that is at page.
Yeah, I'm saying that.
Because if it is I am from 1956, I am over that plot of land by way of sale deed. And the act came in 1958 and amended in 2010. I have annexed that act at page, my lord, it starts at page
53, I have seen that.
page 61, section 20. If the central government is of the opinion that any protected area contains an ancient monument and antiques of national interest and value, it may acquire such area under the provision of Land Acquisition Act 1894, and if the acquisition were for public purpose within the meaning of the act. So if I am from 56, the act came in 58, they have definitely taken over that land under the provision of this Land Acquisition Act. Now, their whole contention before in the show cause notice is this: the persons who are occupying such land are within the prohibited area. If they want to make any renovation over that plot of land, they have to, there is a provision under section 20C, which they have to take permission from the authority in doing that. And we have not done that. That is their whole contention. My lord, our contention that we are, if we are, first of all, not within that 100-meter zone. First of all, my lord, we are not within that 100-meter zone. We are outside the premises of 100-meter zone. In their affidavit, my lord, what I have found it out, my lord, in their affidavit. In reply to their parawise comments, my lord. In page 130, serial page 130, paragraph 9. Well, their statement is the petitioners have the legal ownership over their respective land, which cannot be denied. They have admitted to that fact. Para 9, page 130 in affidavit WPC 6283.
Yes.
Now, in the last portion, last but 6 lines it has started. Para 9, page 130. The petitioner have the legal ownership over the respective land, which cannot be denied. But the MFSSR of 58 does not provide any exemption to landowners, and therefore the notice issued by such and such is in conformity with the act. So, Mala, it is an admitted fact that we are the landowners over the plot of land. We have been acquiring over that by sale deed and patta and some tea gardens over there. But we are over their plot of land. And now, Malad, they want to give us a show cause notice. First of all, they have stated that if you want to do, you can carry out they have quoted the provision of 20A, 20C, 30A. And now, Malad, in page 100, they have said that we have contravened the subsection of 20C and therefore liable for action under section 30A of the Act. So under the rule 38, they want to
They have also annexed this map at page 136.
56, yes.
And they say that you are in the periphery.
My lord, but there is no prohibition that I cannot stay within that prohibited area. I can stay over the prohibited area, but the renovation and reconstruction, if at all to be done with the authority's permission. What they have alleged against us that we have done renovation or other reconstructions or taking care of our old premises is that we have not taken the permission. That is the whole issue. And for that, they have taken recourse to section 38 to throw us out. Rule 38, not section, my lord. I have taken out the rule from that, my lord. It is not annexed to the petition. Rule 38 provides removal of unauthorized building. Your lordship may look into this. My lord, they say that our building construction is unauthorized. My lord, the rule I have to giving my lord that rule. Rule 38. In one way, in their affidavit, they have stated that we are legally occupier or legally ownership is there. This is rule 38. Removal of unauthorized. They are taking recourse to rule 38. But the show cause notice said that we have contravened.
But how do you first ascertain that what is the prohibited area?
My lord, they say that through a map that we are within the prohibited area. But our statement is this, my lord, we are beyond the 100 meters. And we are from 56 onwards. If it is from 56 onwards, they have to show that they have acquired that land under the Land Acquisition Act.
No, if their case is not that not that they have acquired it, but they say that you have violated the
Rule 35.
20A. Section 20A is
That we have reconstructed it or we have renovated without the permission. But we have denied. Our contention is this: these constructions are prior to the long time back now. It is not at present. We are not constructing anything. And it is there. Some premises of ours are within the tea garden area also. So they are tea gardens. 38 says removal of unauthorized buildings. If it is not granted or refusal of license is there in contravention to Rule 35. In the same page 9 ballot in Rule grant and refusal of
No,
license.
you see, that doesn't appear from 136. Page 136 shows there's an orange line. Orange line shows that in 3 places there's a what you call this small unfinished dwelling house is within that prohibited area. Page 136.
Bharat. Is there, yes.
But Mr.
Bharat.
Datta, Mr. Datta, you are appearing as CGC in the matter.
Yes.
Now, if their houses are pre-existing, then you can only acquire it. You have not acquired that land.
The government of India by notification that is 25/9/2033 declared the area.
No, if somebody is inside,
Inside.
then he can't be evicted without you taking recourse to land acquisition.
Inside, my lord. And the
Your act does not say that from the date of notification, everybody who's in the prohibited area has to be excluded. So therefore, you can't be evicted.
Eviction, my lord. 136, my lord. 136 page.
Yes, I'm
of
there
my
at
affidavit.
136. I'm there at 136.
This gazette notification, my lord.
136.
136, my lord.
136 is not a gazette, it's a map.
Map 137, man.
Yes, 137.
25th in middle, my lord. 25th September 1933.
Yes.
Numbers 2133E under section 3, subsection section 3 of the Ancient Monuments Preservation Act 1904. Within bracket 7 and 1904. The governor in council is pleased to confirm notification number such and such dated 25th July 1933, published in the Assam Gazette of the 2nd August 1933, in which the following ancient monuments in the district of Kasa were declared to be protected monument within the meaning of the said act. The next, my lord, Khaspur. This is the this is the monument. It was declared in the 1933, and their land record.
Where is their premises?
My lords.
From this map at page 136 or any other document, where can we find that which is the place where their house is situated?
Small temple.
Or any other document from which
petitioner number 2. Petitioner number 2, petition number 3, and petition number 5.
Where?
My lord, PT number 2. Temple.
PT number 67.
Within the packet.
PT2. So this is outside the periphery.
My lord, there is also a regulated area, my lord. 2 area prohibited area up to 100 meters, and thereafter up to 200 meters. It is a regulated area.
Okay.
Your lordship permits me at page 75, your lordship will find the repeal and savings. The Ancient Moment Reservation Act of 1904 shall cease to have any effect in relation to ancient and monuments. 1904, page 75. Repeals and savings under the new Act of 58,
74,
75.
75.
Repeals and savings.
But it continues.
The Ancient Monument Reservation Act shall cease to have.
Any action taken is saved.
No.
Any action taken is saved. And whatever is covered by that notification is
No.
taken over by this notification,
Mhm.
by the new act.
No,
So that remains. If there is a notification of 33,
no.
then you can't get a protection. But that construction would be illegal.
Your lordship will find in 20, those who are already over there at 20, my lord, 20C. 20C, page 63.
63.
Page 63, 20C. Twenty C, 1 and 2.
So any construction, you have to make an application.
If construction, and which any person who owns building or structure which existed in the prohibited area before 18 June 1992, which has been subsequently constructed, that is, if subsequent. I am from 1956, man.
You still have to make an application before the company authority can
If
accept.
I have to renovate or reconstruct, if I want to renovate or reconstruct, but who were prior to 92, who was there, staying over there.
No, correct. But if the construction is illegal, then they say that they have the power under the rules to.
Rule 38.
To evict you, to remove the.
Well, if I have not taken permission,
No, for removal of unauthorized building, only that removal will be there. You will not be evicted,
not evicted,
but removal will be there.
removal of building will be there. Rule.
Have you made an assessment of what new construction has come up?
My lord,
Have you undertaken an exercise as to what new construction had come up illegally? Is there any survey done?
yes, my lord.
Where is that?
Survey is done, my lord. This is the map, my lord, which is better. And survey is done, and thereafter the scope was not
Where is that?
In the map, they are seeing in the map, my lord, 133.
No, I have not furnished these documents, my lord.
They have not furnished the documents.
My lord, the land documents of the petitioners, my lord.
Allegation is that, my lord, I have reconstructed it. It's not that I am in occupation of that land. Show cause notice says that I have illegally constructed.
Reconstruction requires removal.
Removal. But they have not submitted the documents. What is the excess construction that we have made without a permission?
This is the land in
Khashpur.
Khaspur. Get us any information you have for that illegal construction. What sort of construction had come up?
The survey was done, my lord, in the year 2019-20, my lord.
Where is that?
I have stated in my affidavit, and the item number 13. Page 296. It was separate. Page 130. Not in the affidavit, page 130, my lord.
130.
130.
Yes. Paragraph 10.
Yes.
That in response to the statement made in paragraph 13 of the petitioner, the answering deponent humbly submits that the statement of the petitioners that petitioners building and structure do not fall within the prohibited or regulated area and regulated area is not true. As per the survey conducted in the year 2019-20 by the Archaeological Survey of India, Guwahati Circle, around centrally protected monuments, Kasari ruins, Khaspur, the land of petitioner at serial number 1, 2, 3, 4, 5, 6, and 7, and 8 of the writ petition falls within the prohibited area. The land of petitioner's number, serial number 9 of the writ petition falls within the regulated area. We mark it.
No, but what is the construction which is unauthorized?
Construction, not land. Construction.
Construction, they have constructing their houses and buildings, my lord.
Proposed notice of proposal. The map.
They are occupying the land, encroaching the land. And
So get us better particulars.
Uh,
Because if they have made a construction, we should know what illegal construction is.
without permission from the authority or
No, that's okay. But we don't know at this stage whether it is illegal or you are not disclosing documents. You have to show us something that this is an illegal construction. If you have done a survey, why you are withholding it?
Mallet in prohibited area, only renovation is permitted. And the regulated area, in regular
I understand, but
construction.
if I say the same thing to you, will you understand what you are trying to convey?
My lord,
Will you understand?
yes, my lord.
You'll understand. But we are sorry, we are not being able to understand.
Pardon, my lord,
With this statement you are making,
yes.
can you yourself understand what is the nature of violation? You hear your own statement and tell us, have you understood what is the violation?
I listen
So
to
in the map, my lord, there is the figure is there, my lord. I can produce. You just have to.
You see, I know of the Guwahati law. This Khaspur law, I do not know. The Guwahati law says that if there is a violation, the GMC while issuing a notice of illegal construction will give the description of the illegal construction.
In the map, it is specified, my lord, the RCC building, how many numbers, under construction building.
Where?
This is specified in the map.
Where?
With the right hand side of the map, my lord. The right hand side, my lord, there are 3 areas, protected area, prohibited area, prohibited area.
Yes.
The right hand side bottom, my lord, it is there, look, the RCC building, in the protected area, there is 1 RCC building. Under construction building, 0 huts, 11 numbers. In the prohibited area, my lord, there is no RCC building, but under construction buildings are 9 in numbers. And then 144 numbers of huts. In regulated area, under construction building, 12.
So it is a hut.
Buildings are also there, my lord. RCC and under construction.
No, you see, come one by one.
Three categories are there. The RCC building is there, my lord. Under construction building and hut. 3 things. 3.
No, you see, let us see one by one. In this map, you have first circle is petitioner number 5 and petitioner number 8. Correct? Both are hut. correct?
Yes.
Now come to petition number 2. Petition number 2 is a RCC building with tin. Correct. You have to tell us that this is constructed when?
Well, it is only in the survey, when survey was done in the year 1920.
It's okay. You take a survey, you find this High Court building. You will come to a conclusion this High Court building was illegally constructed in 2024.
We committed that.
That's why I'm saying your own submission, can you understand the nature of violation? So you see, from that we don't understand. You have to tell us that this is an illegal construction. If there is a hut is otherwise not covered by any permanent construction. So if somebody straw of a hut is damaged and they will make a construction, will it come within a prohibited vertical action, even a hut? Because you see, under the Municipal Act, you will find reconstruction. It says it covers replacement of a bamboo pole. That is also a reconstruction. So I can understand if you say that is that. But you have to tell us what has happened actually.
That details we will furnish. So definitely it must have been there.
Petition number 9 is a tin roof. Then petition number 8 is again that hut. Petition number 4. Now, what is this? Petitioner number 1. You say DG and JV. What does it mean? DV and JV is not here. Then petition number 3 is a tin roof. Petition number 4 is a hut. Petition number 1 is again tin roof. Petition number 6 is a tin roof. 7 is a tin roof. Correct.
My letter, they are within the protected area, my letter.
Oh, that's okay. This is what I have been trying to explain to you. You have understood or you have not understood? Or it's only a rehearsal speech made that you will only say that without understanding the submission of the statement made by the court. you see, it'll take us only, it's not that we have not understood what you're trying to say. But you see, there's a difficulty. Come to page 62.
Yes, my lord.
Yes, 62 is 20A,
28.
correct?
Yes, my
Now,
lord.
please come to this. It says construction. 20A2, save as otherwise provided in section 20C, no person other than the archaeological officer shall carry out any construction. Now, please tell us, even if a roof of a hut is changed, will it amount to construction? Where does the substantive act says that you can't renovate? And you see, you come to a rule. Mr. Royce has given us a copy of rule 38. Unauthorized building. Now, according to you, is a tin house roof is called a building? Assam type house will be a building for you?
Yes.
Yes. Then we have to, we have other notions for Assam type house.
Act rule.
It is a construction, but it's not a RCC, it's not a building.
Rule 2 yet 9 act.
Yet and none.
Rule is not. Rule 2 80.
So your rules can't be more than what is prescribed under the act. 20A say no construction, doesn't say repair. GMC Act says repairs. And it has given a description that even a change of bamboo pole would be within the meaning of repair. So that's why I say Khaspur law I don't know, but Guwahati law I know. So there's a definition of what is repair and renewal. Here it doesn't say so. You don't prescribe that for this even for this repairs and renewals. You'll have to apply. So you want to bring better particulars, or you leave it to me to pass orders?
Better particular. We bring better particular.
Better do it. Also, it's a duly represented. So, in view of the provisions of section 20 capital A of the Ancient Monuments and Archaeological Sites and Remains Act of 1958. And Rule 38 of the Assam Monuments, Ancient Monuments and Archaeological Sites and Remains Rules of 1959. On a query of the court, Mr. A.K. Dattar and CEC placed for some time to obtain instructions and to file better particulars with regard to the unauthorized constructions referred to in their notice. Dated 28/6/2022. This is your input notice?
Various notices. Yes. Several notices are there.
No, 87. I have flag mark 87. Is it right or wrong?
One is page 99, my lord. One notice is there.
99.
99. One such notice. 6283, page 99. Show
Okay, 28/6/2022. Proposed notice. Show 29/6/2022. Okay. How much time, Mr. Datta?
2 weeks, my lord.
Huh?
2 weeks time.
2 weeks.
One particular
Okay.
month.
Previously, there was
Date after 2 weeks.
previously there was an interim order, my lord.
Interim order passed earlier. Stand extended in next list on. After 2 weeks, give a date. Okay, there's a meeting I got. continue post lunch. I'm sorry, there was a meeting.
Item 6, fixed at 2 p.m.
You've given copy to,
Yes, my lord, I have stopped.
you're there? Okay. We are along this petition.
Lordship, I'm appearing on behalf of my senior RS Chaudhary, who is in trial court today.
We are along this writ petition. I'm saying counsel to the petitioner. Also heard Ms. M. Burman and the government advocate appearing for respondent number 1,
4 and 5.
4 and 5. As well as Ms.
H. Hoppy,
H.
H. Hoppy on behalf of.
Just write the exam. Appearing on behalf of Ms. R.S. Chaudhary, Leonard. Standing counsel for the respondent number 3. Next, brother. The case of the petitioner is that her husband, namely Sona Uddin, alias Sona Uddin Sheikh, was murdered on 26/10/2004 by the, allegedly by the FIR named accused persons. In respect of which, Bagri Bari, BARI, Bagri Bari PS case number 143 of 2004 was instituted. Full stop. The by judgment and order dated 7/9/2018, passed by the learned additional sessions judge Bilasi Para in sessions case number 65 of 2007, the accused persons were acquitted. So he was convicted. One of the accused persons, namely Rahij, R-A-H-I-J, Uddin Sheikh, was convicted under section 302 of the 323 IPC. Full stop. Thereafter, the petitioner submitted a representation dated 12/11/2018 before the Member Secretary, Assam Legal Services Authority, for providing victim compensation as such payment was not as the compensation was not received, the petitioner approached this court by filing a writ petition, and this court by order dated 30/4/2019, passed in WPC 1563 of 2019, directed the District Legal Services Authority, Dhubri, to take up the claim of the petitioner for victim compensation under section 357, capital A, CRPC. And after due inquiry, decide the quantum of compensation to be awarded in terms of the government notification dated 1/2/2019 within a period of 2 months. Full stop. Accordingly, the petitioner moved the Secretary District Legal Service Authority, Dhubri, on 10/5/2019, along with all requisite documents. Full stop. Accordingly, the Secretary District Legal Services Authority, Dhubri, by an order passed in proceedings of REG number 13/2019, passed an order dated 20 January 2020 in proceedings of REG number 13/2019, and awarded a compensation of ₹1 lakh to the victim under the Assam Victim Compensation Scheme, 2012. The next, the aggrieved petitioner moved this court again by filing a writ petition. And this court, by order dated 28/2/2020, passed in WPC 1462 of 2020, disposed of the writ petition by allowing the petitioner to file an appropriate application before the Secretary, District Legal Services Authority, Dhubri, for reconstitution of the case of the petitioner in light of the order dated 30/4/2019, passed in WBC 1563 of 2019, with a direction to dispose of the application within 30 days. Full stop. The said order of the court was forwarded by the petitioner to the Member Secretary, Assam State Legal Services Authority, by letter dated 11/3/2020. With a copy to the Secretary, DLSA Dhubri, and so however, the Secretary District Legal Services Authority, Dhubri, by an order dated 13/3/2020, maintained the award at ₹1 lakh. But according to but after due approval, the check of ₹1 lakh was delivered to the victim on 20 January 2020. First off, the said authority expressed an opinion that this court had not specifically directed to award a compensation of ₹5 lakh to the petitioner, but the authority was directed to take up a claim. So accordingly, the prayer for further compensation was rejected. First, agreed by the said order, the petitioner has approached this court once again. With a prayer to set aside the impugn order that is 13/3/2020 in proceedings of REG full stop. Number 13 of 2019. As well as the passed by the Secretary DLSA, Dhubri, in connection with victim compensation application number 13 of 2019. Stop. Upon hearing the learned counsel for the petitioner as well as the learning. So finance will be appearing.
Mr. Oh, P9, P9.
P9. Okay. What number 2 is P9? Learning counsel. Having heard the learned counsel for the petitioner as well as the learned state and departmental counsel for the respondents, comma, the notice of the court takes notice of the fact that not only in the judgment and order dated 34/2019 passed by this court in WPC 1563 of 2019, but also by the order dated 28/2020 passed by this court in WPC 1462 of 2020, there was a specific direction to the Secretary, District Legal Services Authority, Dhubri, to reconsider the case of the petitioner by specifically referring to the government notification dated 1/2/2019. The said government notification dated 1/2/2019. Where is that copy? Page?
My lord, page 25
25 and accept.
and accept to one.
Serial number clause 6. The date.
Serial number 6. my lord.
In row number 6 of the schedule, this page 25 has a serial number, huh? The number so and so, so and so, so and so, dated 1/2/2019. Huh? Have that number also. Comma, the compensation payable under the Assam Victim Compensation Scheme, 2012, in case of death, is raised from rupees 2 lakh to rupees 5 lakh.
No, my lord. Minimum 5 and maximum also 5, my lord. Page
Hmm?
25.
Oh, it's a 5 lakh.
Five.
Is maintained at rupees 5 lakh. Which is both the minimum and the maximum quantum of compensation. Full stop. Therefore, comma, when this court had passed 2 consecutive orders in WPC 1563 of 2019 and 1462 of 2020 to consider compensation under the government notification dated 1/2/2019. It is imperative that the quantum prescribed in the schedule to the said notification has to be adhered to. Full stop. Next, for the district legal service, the secretary, member secretary, district legal services authority, Dhubri. While passing the imperial order dated 13/3/2020 in victim compensation application number 13 of 2019, being a judicial officer, is expected to apply his judicial mind and appreciate the contents of the notification. To stop. It would not be open to the secretary, member secretary, district legal service authority, Dhubri, to make its own interpretation of the contents of the government notification. To stop. We find the said approach of the secretary, district legal service authority, Dhubri, contemptuous. And therefore, this is a fit case. To have this matter referred to the registry for examination on the administrative side. Next paragraph. The court is of the considered opinion that as it's the primary duty of the district legal services authority to pass an appropriate order on an application for compensation under section 357 capital A CRPC, this court on 2 occasions had referred the matter to the said authority for passing an order. However, the said authority did not take note of the government notification. The contents of the government notification dated 1/2/2019, especially the entries made in row number A6 regarding quantum of compensation allowable in the case of death. Therefore, the imperial order dated 13/3/2020 passed by the Secretary, District Legal Service Authority, Dhubri, in connection with victim compensation application number 13 of 2019 cannot withstand the scrutiny of the court, and therefore the said order is hereby set aside and quashed. Next, accordingly, the having noted that the Secretary, District Legal Service Authority, Dhubri, has turned on the has limited the quantification of compensation to ₹1 lakh, whereas the notification gives a minimum and maximum quantity of compensation at ₹5 lakh. The court is hereby inclined to direct that the member secretary, District Legal Service Authority, Dhubri, shall now pass appropriate orders pursuant to this order of the court, allowing compensation of rupees 5 lakh to the petitioner on account of death of her husband. In homicidal death, which is the subject matter of judgment dated 7/9/2018, passed by the Learned Adjustment Session Judge Bilasi Para in Sessions Case number 65 of 2007, arising out of Bagribari PS case number 143 of 2004. Full stop. This needs to mention that that on funds being released by the competent authorities, the said awarded sum would be released to the petitioner. Yes, finance would be required. This, because this compensation has to be released. This money will have to be placed to the DLSA. The proposal to them may be sent to the competent authority within a period of 1 month from the date of the exercise of passing an order and communicating it to the competent authorities for release of funds should be made within a period of 1 month from the date of receipt of certified copy of the order. Next, you hope and trust that the competent authorities in the finance department shall place sufficient funds to the disposal of this Secretary the District Legal Service Authority Dhubri to enable the payment to be released to the beneficiary of the victim page number under the victim compensation scheme, 2012, in terms of notification dated 1/2/2019.
May I point out one thing, my lord? Here is petitioner's claim is for 4 lakhs, in addition to the payment. So I think that
On adjustment of 1 lakh rupees already released.
that has to be
Quantum
there
of contribution would be
in respect of payment.
would be only for the balance amount, which is
Yes.
rupees 4 lakh. Yes.
Obvious.
I inform Mr. Nair about this.
Just tell it.
Obvious.
This repetition has been allowed at the motion stage without issuance of notice on the respondents.
Daily list item 16.
Particularly this matter of pleadings are complete. The matter was initially for 2 prayers for registration of the affair. Secondly, for restoration of possession. However, only on the prayer for restoration of possession notice have been issued. The case is, Lordship, without an order of the competent authority, I have been illegally evicted, and my building has been demolished without any notice. It is done as per the admitted affidavit. It is done on an application made by the local MLA. Lordship would fix a date for a final hearing in this matter. Lordship.
See, this, you have only purchased by way of a possessory right. Possessory right in respect of a government dag. How much that would be enforceable, number one. The second is that you're referring to the prayer for compensation.
Yes.
Compensation is something you'll have to approach the
Yes.
civil court.
Yes.
In the rate court, we can't give you compensation.
Lordship, my point is that maybe under Rule 18, notice is not necessary for eviction of in a government, but an order from the competent authority, that is the DC or the delegated authority, is necessary, Lordship, as per Rule 18 itself. So, secondly, it had been done under the dictation of the MLA and not by independent application of mine. At page 63,
No,
I have
MLA is
quoted Rule
ultimately,
18.
ultimately is a representative of the people. This will be 18 to settlement rules.
Yes, Lordship, I have also quoted the rules at page 63 of my reply. Sorry, Lordship. 53.
53.
53.
Rule 53.
No, page 53, I have quoted the rule.
Oh, no. Let me go to the book. The place where I read it regularly, I understand better. From the same book, I understand better.
Yes, yes.
Old habit. Yes.
Subject as herein provided, Deputy Commissioner may eject any person from the land which no person has acquired the right of a proprietor, landholder, or settlement holder. Therefore, the authority to eject is given to the Deputy Commissioner, who can by an order eject me. But when there is no order at all, Lordship, just coming with some bulldozers and on a fine morning, they have ejected me. And I have, when my examination of my son was going on, Lordship, at page 24, I have narrated the entire incident in my FIR, which was also not registered.
Okay, in your affidavit, you don't disclose that notice order.
Which order?
Eh,
We say that, my lord, that was.
This is an affidavit filed by respondent number 3, circle
ma'am.
officer.
Yes,
You're not referring to
that,
the
that
order
was,
passed.
that was amended. The power has been given to the circle officer.
Oh,
So
that's okay.
circle officer.
And where is the
accept-
order? And where is the order?
My lord, something has been said.
Because you have only annexed the authority. But this order you have still not disclosed. So you'll have to presume that there is no order. Because Mr. Talukdar,
My lord,
you'll find it from Rule 3 of Rule 18.
18. My lord.
Order is required to be communicated.
Our lordship, that has been communicated. But when it is roadside land, my lord, that requirement is not there.
No, but please find out.
There has to be an order, Lord. Yes, well.
That means you are not referring to any order. Which would mean that the order is not there.
Lordship, at para 7 of my reply, I have categorically stated that firstly, the respondent number 3 circle officer Tinsukia has not brought on record the order of delegation by the Deputy Commissioner, which can.
That's there, that is there. That is there, we'll know about it.
Lordship may come to
But
paragraph
that is
8,
a notification, state government notification.
amendment, delegation.
Delegation is there.
And paragraph 8 we have said.
Paragraph 8.
8. Just middle portion of it. In fact, the petition of the local MLA, Lordship has also got it. my lord. Petition of the local MLA was submitted to the Deputy Commissioner.
Just
Tinsukia,
a moment.
and from the
Yes.
45. Middle portion. In fact, the petition of the local MLA, Lordship has your lordship got it, my lord.
Yes.
was submitted to the Deputy Commissioner Tinsukia, and from the Deputy Commissioner's office Tinsukia, the same was forwarded to the Circle Officer Tinsukia, white dated number so and so, dated 16/11/2022. The Circle Officer Tinsukia Revenue Circle then carried out a field survey. And found that
Notice before eviction is not there.
notice is not required to 18(2) because
No,
roadside.
18(2), no, C 18(3), notice is required, mandatory requirement. C 18(3).
And there's a finding, my lord, the field survey and found that a portion of the structure fell on the land reserved for road.
But, okay, road I can understand. But you see, the 3 says what? In all other cases, it is considered by a publication of notice. Prescribed this so and so. Therefore, you see, you have to give time to him to remove. So that is what is happening in all cases where 18(2) notices are issued.
It comes under 82.
No, but you see 18(2), you see, if you don't give a notice, what happens? You come to this in the middle.
82.
That has been previously reserved for roads, roadside
Yes.
land or grazing field or so other public has entered in possession of a land from which he has been excluded by general or special orders. That means first there has to be a restrainment. And
where your lordship is reading.
There's 18(2).
18(2). When such person has entered into possession of the government cast land or wasteland or estate over which no person has acquired the right of a proprietor, landholder or settlement holder or any, and that he has previously been reserved for roadside land or for the grazing of the village cattle or for other some public purposes, or has entered the possession of the land from which he has been excluded by general or specific order. That is one
So
part of it.
That's one part. The
One
first part is number 1.
First
It
part is
should have been-
reserved for,
No, it has been reserved.
reserved for public land.
Correct. So you have to
roadside
show, you'll have to show that it's a reserved.
Yes, we have
for
said
land.
in our affidavit.
No,
that
no,
it was-
actually it will not show. Because that will only be from the map when you can say that this is the place from where is evicted. You see, if it is reserved for road, you'll have entries in the chitta saying that it is reserved for road. It may be a road, it may not be a road. And then next part, after this, you see,
Yes.
which is excluded general orders. And when there is no bona fide claim of the right involved, he may be injected.
No bona fide claim or right to
Yes.
involved.
Now, if you don't give,
There is no right because he was
no.
occupying a government land.
Please don't presume that he doesn't have a right.
Right.
Let us
So
say he
he
has a
has to
bona fide claim.
establish his right, my lord.
No.
He has to establish. Lordship may kindly see.
No, let
He-
us see. We are not going by what is there. We say we don't jump into a conclusion that he has no right.
Yeah.
But assuming that he has a bona fide claim, where will he ventilate? You see, somebody will have to decide that his claim is not bona fide. Whether he is a right or wrong, whether he is right or wrong, we are not.
From
discussing
his
that.
own petition, my lord, lordship
The-
will kindly see.
The
He is,
notice will give me the intention, opportunity.
my lord, lordship will see at page 31 of his petition, my lord.
Page 31.
Yes, this was revenue received. It is only Bedakhali Jorimana. Bedakhali Jorimana, not his Madillion.
Yes. So that is within the scheme of the government.
And your lordship kindly come to.
You know, Mr. Talukdar, after all these are happening, the government has come up with a circular that anybody who is unauthorizedly issuing this basically Jurimana or a Tozi revenue will be doing something which is illegal. But I have not found any of your officers being targeted for issuing this basically collecting basically Mana.
That's a different thing altogether because they are occupying the land as a fine they are paying this.
Correct.
That has been
But
settled
there's a
in
government
Radhakant's
notification
case.
not to do it. There's a
And-
government notification not warning them not to do it.
And page 18, your lordship, may turn on to page 18.
18.
Yes. This was a agreement between him and petitioner and Sasi Bhushan Singh.
Correct.
He was the holder of the land. So this was made on December, 8 December 2016. So he sells it on December 16. 8 December 2016. Then your lordship will come to page 34. This is an application
32.
34.
34.
This was made by the original landholder. In 2000, he says that 2022 he applies for. Fourth place, application to 34 to no. কেতিয়া কৰিছে? Date to go. 22. So in the year 2022, he applies in the name of the original one. Not owner, possessor.
But Mr. Bara, once your prayer is for compensation, you'll have to be relegated to the civil court. High Court will not assess compensation. You don't have mechanism to assess compensation.
Firstly, I am against a illegal action by a statutory authority.
No, whatever we, that is, what has happened.
People will take I'll bring some judgment wherein statutory authority cannot act on an application by higher officials or a minister. They have to apply their independent mind. There has to be an order as per the statute also. Therefore,
They did a verification. They did not act on the dictates of the MLA. And MLA is a representative of the people. We can't say that he doesn't have a right to inform the authorities about illegalities.
no,
So-
if it is roadside structure, everybody who is occupying their land has to
Negative
be.
equality, we won't accept that argument of negative equality here. if they have not done to others, you can't be singled out. That can't be an argument.
What I
The fact
submit
is
is
that
it is
if
done
you are-
for political vendetta, Lordship. That is-
Maybe,
But.
but can I arrive at a satisfaction? This is a political vendetta. Those, what you call for that, we have to hear the persons who you are accusing of.
We have made respondents, respondent, the local MLA, he has received notice but has not, chose not to appear. Lordship has noted that in the last order. 5-4.
Five is a party. He's the one.
Yes. Lordship, Feroz, Lordship last order, it is 5-4.
It's okay, once you say that, we're not questioning you then now. It's a question of compensation, quantification has to be made. It can only be by a civil court.
My only submission is.
Restoration of the status quo ante, that can't be done when you can't establish your indivisible right to be on that land. The only relief you can get is for compensation.
Lordship, at para 17 at page 13, I have stated that why this, I have opted for filing this petition. It's 30.
There's no bar. 154 and doesn't say that compensation can't be claimed in civil court.
Compensation can, please.
So to close it and delegate you to approach the civil court, to get a compensation from the authorities.
Lordship, Lordship will give me one date to satisfy your Lordship.
Mr. BP Baran and counsel for the petitioner, as well as Mr. BJ Talukdar Lanet.
I'm
Senior counsel,
22-4.
assisted by Mr. PK Medhi, Lanet counsel, Government Advocate appeal for respond number 2, 3, and 4. And before that, Mr. A. Bhattacharya for respond number 1. None appears on call for respond number 2. Sorry, 5. On the query of the court, in connection with the prayers made in the writ petition, on a query of the court, that as the petitioner would not have an indivisible right to be restored to possession of the government land. And secondly, that in respect of claim for compensation, would entail adjudication as to the disputed questions of fact. For which, why the petitioner should not be relegated to the civil court for seeking compensation. The learned counsel for the petitioner press for some time to address the court. List after. When?
Lordship, 2 weeks.
After 2 weeks. But Mr. Talukdar, that part of your argument we are not satisfied. with regard to the issues of notice, because once you say that, once the act says that unless you have a bona fide claim.
Unless you have
Yesterday,
a bona fide-
yesterday also I asked that question, same question. Today
But
I'm repeating it.
Unless there is a bona fide claim, if it is roadside land or government land, we can evict for it. That is the.
No, but not without
I'll-
notice.
I'll-
But you see, you come again, this I've read several times and that's why we are asking.
18 to.
He may be ejected or ordered to vacate the land forthwith. So this.
Ejected forthwith. That is
Or-
one part. Or is.
Therefore, you'll have
is
to-
done.
No, no, you'll have to then show us why you have used or. Why you have taken recourse to the second option.
Lordship, I'll address it, Lordship. So 18 to 2 years.
Madam, may I say? Lordship has referred one particular method, that is.
I'm aware of it. That's why we are asking questions.
that is
I'm aware of
finding
it.
for the division.
No, you see that, you see, my theory is very simple. Unless unless a larger bench or a superior court restrains me from entertaining such application, because you see Supreme Court orders, it says that we are in session of the matter, therefore no court in the country will take up this issue. Correct. So they are restraining others to take it up. And with that restrainment order not being there in this court, I will not say that I recuse myself just because a issue is pending before the division bench.
Because
It's a question of recusal.
earlier decision, that Unagav case, that was first in point of that, that says notice not required.
That's okay.
Later judgment says it's required.
That's okay. But still, you see, the question is when the act itself says it's a literal interpretation of an act, plain and simple interpretation of an act, which requires no external aid. You are not importing anything from outside and saying that you read this in the help of that rules of interpretation. You are not saying it. It's a golden principle of interpretation. The act itself, this 18(2) itself refers to a notice. Therefore, if you are exercising another option, why you are doing so? That is a question we can always ask to the authorities. You have two options. Why you are using the second option? And the authorities can't say that we will not inform the court about that. We have a discretion. Yes, you have a discretion. Your discretion is not unfettered. That means then if you see, why does not the government take adverse action against those persons, those officers who are issuing notice under 18(2)? That means they will be doing illegality. So when one set of officers are doing it, the government must act in one, in unison. We know the government. We don't know District Commissioner X or District Commissioner Y. When we are referring to the government, we are referring to the government as a unison. It's a one entity. So 10 people can't act according to their whims and fancies. Somebody will say, I'll give a notice. Somebody will say, I'll not give a notice. You can't do that.
Lordship, we made an RTI application which is annexed to the petition. The deputy commissioner doesn't even know that such order. They have referred the application to the ADC. He have referred.
No, that's because the deputy commissioner may not have he's not required to. He's not a custodian of the document of every district. He's not an office of record. High Court will say that we are an office of record. Therefore, we keep those records.
I'll
District
address-
commissioner is not an office of record.
I'll address on these issues, madam. Probably. I'll get back.
There's a statute and a statutory process they have to comply with.
It's okay. We have put a question. Respond to it. Oh, just a moment. I would forget. Just record it in the order.
Yes.
Insofar as the government respondents are concerned, we find that the requirement of notice is contained in the provisions of Rule 18(2). So though it's an option provided, the learned senior counsel appearing for the state respondents and the standing counsel for the revenue department, shall address the court as to why the concerned official is not required to record reasons of not issuing a notice to the person sought to be evicted. Yeah, so now we'll understand what we address deeply.
Item 17.
Yes, Mr. Nayak.
On last date also petitioner preferred not to appear, Lordship. This is basically a matter, Lordship, filed praying for removal of illegal street vendors, Lordship. Some areas has been mentioned.
Yes. Because you see now, Mr. Nayak, this, even if the petitioner is not there, we will like to continue with this matter.
Yes, Lordship.
Because it has become very difficult in Guwahati city to walk. You cannot show me one stretch of land, of road, of 1 kilometer where I can walk straight.
Yes, sir.
So therefore, I am a law-abiding citizen. I want to walk on the footpath, and the state is compelling me to walk on the road and suffer an accident.
Lordship.
You see, there is another difficulty. In any stretch of road you walk for 1 kilometer, you will find the roads are uneven, the footpaths are uneven. At certain footpaths, you will find these rods coming up. Somewhere you will find this slab missing. And some places when there are vendors, you come down. I normally walk many times from the court to my quarters. I walk many times. But you will find there's a strange phenomenon. Half of the road is covered by sand, which is either construction sand or it's a dirt from the road which is not picked up. So in both the sides, 25% of the road is covered by sand. And therefore it's a difficult proposition to walk. Therefore, the only place I can walk is either the footpath or the center of the road.
Yes, sir.
And especially you will find ladies and girls, they'll be compelled to walk because of their, if they are wearing a sari or a mekhela, they can't walk on this sandy part of the road. There are two namghars at Mali Bagan. At evening from 6 onwards, you will find that on some days there is walking in. And most of them you will find walking on the middle of the road.
Lordship.
That's why even if the petitioner doesn't want to proceed, we'll like to proceed with the matter because every road is now covered by this.
In that case, Lordship will allow me to file my affidavit. I have received some instruction.
Okay.
But only difficulty will be, Lordship, the body of the petition, it's basically relates to Beltola market, Lordship, bi-weekly market.
No, this is Tokyo Jalukbari.
Tokyo daily, yes, Lordship. It's a
Jalukbari.
different one. Yes.
Because in Jalukbari, because in Jalukbari, again, this part where is complaining.
Lordship.
I hope you travel.
Yes, Lordship.
At times.
I am aware about that.
When you go to airport, you'll find that the street vendors and this, what you call this, share taxi and all, occupying the entire bridge up to the bridge point at Saraigat.
Lordship.
Vendors are there, both sides. You are permitting vendors. Few moments back, we were talking about roadside land being occupied by encroachers. Very conveniently, the state government action becomes questionable, the manner in which you proceed. Not you, you means, not Mr. Nayak, but the authorities from whom you are representing. So why there should not be street vending zone implemented? And there's another thing, Mr. Nayak, it's a social evil which is coming up. I know it because I belong to the community where people are mostly businessmen. So even if I don't want, I get information. You see, let us say a shop X, who is a middle class shop, is situated in a legal way. He's doing his business in a shop within the footpath. He's doing it. You ask from him, the landlord wants a rent from him. The authorities want the trade license from him. Labor will come and want the labor license from him. And then with one or two more permissions, I don't know, he will operate a shop. And to the same man, if you, I can give you timing. If you can tell me the market you want to visit, I can tell you the timing where if you stand, you will find people coming and collecting money from them. These roadside vendors. At least 3 places I know of. Fancifizar I can tell you. Yes, SS Road I can tell you. Paltamjar I can tell you. These 3 places I know of, I can tell you. Now, from a street vendor, you don't collect except for this something which I can say in the open code. You collect, people collect, not you, means people collect unauthorizedly. They have no other taxes. So therefore, you are making a legal person compete with illegal persons.
Even the GMCs keep collecting fines, lots. These are not.
That is the worst part.
Yes.
It's not fine.
Lots.
You show us, we give you 1 month's time. Show us from any place of these 3 places I am telling you. Paltamjar, this Fancifizar, HB Road, and the SS Road. 3 roads I am naming. You show us the amount of fine collected. You'll find none. Fines are collected only on 2 occasions, just before Bihu and just before Durga Puja. And then that is done after you pick up their goods. Then you impose a fine to justify your picking up of the goods.
Probably
What
they collect every day, but
what is collected is a parking fee,
yes, Lord.
which you can't. It's not a notified parking place. You are collecting parking fee from them. My problem is that I walk and go. So I know about everything. I don't normally travel in you will not find me in Fancifizar or in Paltamjar going in a escort car. I normally walk and go. That's my problem. Many things I can see.
Lots of will allow me sometime. Lots of in the meantime, I will try to find one.
Yes, yes, please. But tell them you can show this today's proceedings video and then tell him that the court is asking these things also.
Definitely.
The counsel for the petitioner is not present. Nonetheless, in view of the issue of illegal and unauthorized street vending, which is agitated in this repetition, the court would is desires to have the stand of the respondents be brought on record in respect of illegal vending, which is infested almost all the roads, all the main roads of the city of Guwahati. Next paragraph, Mr. P. Nayak, understanding was for the GMC. Praise for is granted. 3 weeks time.
Kindly make it 4 weeks.
4 weeks time to file affidavit in opposition of the respondents. You also want to say something? The government.
No, I'm appearing for the board, pollution board.
Pollution board has nothing to
Very
say,
limited.
but you will have to say, I think.
I have appeared. I have appeared on behalf of the respond numbers 7, 8, 10, and 11.
Who are they?
They are the deputy commissioner,
No, so you'll have to take a stand because this is administration problem. What do you do? What do you have to say about this? We also would, we would also direct the district commissioner, Kamrup Metro, to file an affidavit in opposition regarding the stand of the district administration on the issue of illegal vending, illegal and unauthorized vending on almost all the roads, the main roads of the Guwahati city. List after 4 weeks. Give a date after 4 weeks.
Just out of turn, may I, the last week, Lordship wanted to have an inquiry as regard the Deputy Commissioner's office, whether they are holding some meetings with the bank officials.
Yes.
Yes. So I have already consulted with the Deputy Commissioner office. So they told that every quarterly they are holding a meeting.
quarterly they are
Yes,
holding.
that
Okay.
meeting is called District Consultative Committee meeting as
Okay,
regard
thank
proper
you,
implementation of the government schemes.
Thank you.
So that is regularly done.
Thank you
Yes.
so much.
I think the matter is listed next Monday or 6th. So I have just marked it and I just
No,
remember.
just wanted to keep myself abreast.
Yes.
Many times there is a disconnect. We don't
Yeah.
know what is happening in the field.
7th of June.
Because even today we had meetings for the ensuing Lok Adalat.
Yes.
The there is a lack of decision-making authorities. So therefore, very difficult to have a good settlement made in Lok Adalat. That's why I'm just collecting information, to see how it can be. Yes, item 20. But thank you for your information.
Item 20.
May please your lordship, the election matter lordships. After obtaining the permission, the building was constructed, lordship. Page 13, lordship.
With that one instruction, lordship, I would say.
Page 13, lordships, the permission lordship, construction permission.
Why you yes. Oh, yeah, got it. No, we'll have to vacate your, this order. You file your affidavit.
Lordship,
You better do it.
Lordship,
How much time?
2 weeks.
2 weeks. Okay. Mr. N. Amit and counsel with the petitioner is present. Mr. G. Henrik Leonard, standing also for the revenue department, sorry, Leonard, the government advocate has submitted that he has received Parava's comments in the matter, and he prays for him granted 2 weeks time to file affidavit in opposition in the matter. Post this after 2 weeks. You do it because unless you bring it on record, you will not be able to do anything. Instructions we are returning.
21.
May please, Lordship. This is case of electrocution, my lord. The report from my lord inspector is required in this case. Testament number 10. I need some time under that report not yet received, Lordship.
Electrical inspector report is not available.
Lordship.
This 23 matter.
My lordship.
Who's for APDCL?
I'm
You're there. All sides are represented. Mr. J. Henrik Leonard, government advocate, prays for some more time to produce the inquiry report by the Office of the Chief Electrical Inspector, Government of Assam. Next paragraph. The said authority shall take note that notice of motion was issued in this case in this requisition on 11/10/2023. Until date, the Chief Electrical Inspector, Government of Assam has not produced the statutory report, which is required to make under the Electricity Act, 2000. Electricity Act is 2003. 2003. It is made clear that if the report of the Chief Electrical Inspector, Government of Assam, within bracket respond number 10, is not produced on the next date, appropriate orders will be passed for requiring his personal appearance before the court. For which appropriate orders will be passed on the next date. Next, by the done government advocate shall transmit a downloaded copy of this order to the respondent number 10. Timely compliance. After 4 weeks, give a date. The electrical inspectors for the report of the Chief Electrical Inspector, Government of Assam. After 4 weeks, give a date.
7th of June.
Published.
22.
May I please, Lordship, in this case, my lord, as per the previous order, my lord, the proposal was sent, my lord, to the respondent one for payment, my lord.
Yes, Lordship's affidavit has been, my lord, ready. We are sending for betting, Lordships. My lord, some time ago.
Affidavit of which authority?
My lord, Deputy Commissioner Udalguri, Lordship.
all sides are represented. Mr. J. Andy Karnab, government advocate, have submitted that the affidavit in opposition by respondent number
Respond number lordship two or three lordship.
three
Three.
is ready and will be sent for waiting and filing. Accordingly, prays for how much time?
2 weeks, lordship.
2 weeks time to file the affidavit in opposition. Next, for a list on date. 42 weeks.
2005. 23.
May I please, your lordship? Lordship, 3 weeks time may be granted for filing a reply to the affidavit in opposition filed on today by the private respondent.
Respondent number 62678 has filed affidavit in opposition, lordship.
All sides are represented. List after 2 weeks so as to enable the learned counsel for the petitioner to file affidavit in reply against the affidavit in opposition filed by respondent numbers 6, 7, and 8.
Lordship, there is an interim order.
Okay, interim order passed earlier stands extended till the next date of listing. List on your date after 2 weeks.
2205.
24.
Item 24.
May I please, your lordship, kindly matter may be passed over for the time being.
For the time being,
Yes, your lordship.
okay.
Bless your lordship.
25.
Okay, notice is to be sent. Okay. Heard the petitioner in person.
I'm appearing on behalf of Mr. S.S. Roy. He has to
Okay.
leave court.
Also heard Mr. A. Bhattacharya, learned counsel, appearing on behalf of Mr. S.S. Roy, learned CVC for the respondents. Next, please. You should notice on this application and file under section 11(6) of the Arbitration and Conciliation Act for appointment of arbitrator. Stop. Response, if any, we filed within. This is, you can do it in 3 weeks.
Right.
Your lordship, give 3rd June the date, because one is there, already
We
is there.
filed within 1/6/20, within 1/6/2024. With a copy to the, with a soft copy sent to the petitioner in person. When did you say?
3rd June.
3rd June, okay. List on 3/6/2024.
Nine.
Yes, 26.
Item 26.
Similar. Same order.
Okay, same order.
Much okay.
27.
My lord, so far this matter is a very urgent one. The matter is very urgent one in this particular case. The private respondent number 6 has filed the affidavit in opposition.
Just,
And I also filed.
I have got a
reply today on.
just a moment. That is the rule. Yes.
My lord, the private respondent number 6 is concerned, my lord. He has filed the affidavit in opposition. And I also filed the reply, my lord, to that affidavit in opposition. And so far the respondents number 2, 3, and 4 are concerned. They have not filed any kind of affidavit, my lord. Even though the matter is urgent one, let them give the last chance of filing within 15 days, my lord, and matter may kindly be listed after for disposal, final disposal. my
If they don't want to file, you can't compel them.
Okay, I have received the, I'm going to file an affidavit.
Okay,
I have filed,
no, it's okay. I can compel the government.
I filed, I reply also filed.
Government
Today,
is-
just now I received the reply.
Yes, day
Yes,
before yesterday, he
yes.
filed the affidavit in opposition, and today I filed. That is the delay.
I'm very grateful.
It's because today is a bank working day.
Yes. So that, my lord, the matter is urgent.
Okay. All sides are duly represented.
A short time may kindly be given to the other side to file the affidavit in
Yes.
opposition. And matter may kindly be fixed for final hearing. At the
No, final,
admission, at the admission stage, my lord, for disposal.
All sides are represented. Mr. J. Andy Leonard, government advocate, submits that he has received instructions and would be filing an affidavit in opposition within 10 days. 2 weeks, within 2 weeks. List on, give a date after 3 weeks. List on so and so. The affidavit in opposition by the state respondent shall be filed at least 2 days prior to the next day's for listing.
29/5.
By 27th, you'll be filing your
Prior to it, my lord, let it be possible.
2 days. Before 2 days, you will file it.
But
Understand? Before 2 days, you will file it. 27th, you file it. 29th, we are fixing. Item 29.
In this case, my Jamindar land settled, my lord, in the year 1988. Thereafter mutated, but behind our back, my lord, in the year 99, my lord, the land has been again khas land, my lord. Subsequently, we filed our neighbors, filed one repetition.
Where is the order?
My lord, this overt judgment is here, my lord.
Where is the order?
Lordship,
Where is the order?
other honorable, this honorable court's
No,
order.
no. The order by which your land was made khas, where is that?
Oh, yes, my lord. That land, my lord. It is a common order, 16/7/99, page, my lord, 30.
Where is your order of mutation?
Yes, my lord. That is, my lord, mutation order is, my lord. Local vernacular page, my lord, 27. Yes, my lord. And let page
What is the
24 also.
reason?
my lord.
You got reply?
No, my lord, I need some instructions, my lord.
You
Request for
see,
time.
we don't know when this bifurcation took place of the districts. This come to page 27.
Yes.
This order is passed by the additional deputy commissioner. Correct?
Yes, ma'am.
He's of district Bongaigaon.
Bongaigaon.
Now you are, the page 30. Your commission secretary says
Yes.
settlement records were corrected in Abhayapuri town on the basis of orders sent by different additional deputy commissioner of Bongaigaon district. Now, what is the illegality in it?
No, the earlier round of litigation, this order was set aside.
Where is that?
That order is page, my lord, starts from, my lord, page 53.
Page
Page?
61 is the operative part.
61.
Yes, my lord. Not 60.
That's
60.
one. So then we'll have to direct the same thing. The authorities will consider it.
Yes.
It may,
They have to first do an inquiry and thereafter this.
yes, so they will follow the directives given in this order.
Yes. Yes.
Yes, my lord.
Copy Vigore. We dispose of the repression then
Yes.
for Mr. H. Das, learned counsel for the petitioner. Also, Mr. A. Bhattacharya, learned standing for respondent number 1 and
One and
2. And Mr. J. Hendrik, learned government advocate, appearing for respondent numbers 3 to 6. It is claimed in this writ petition that the petitioner got allotment of a plot of land measuring 1 katha 15 lecha situated at village Abhayapuri, and the said land was mutated in his favor by order dated 23/7/1998, passed by the additional deputy commissioner
Bongaigaon.
Bongaigaon district. Bearing number BRS full stop 87/95/12 dated 23/7/1998. And accordingly, the land revenue records were corrected. Full stop. However, the Commissioner Secretary to the Government of Assam, Revenue Department, provide order number 63030. Order number so dated 16/7/1999. Directed the settlement officer, Gwalpara and Bangaigaon at Gwalpara to take immediate steps for cancellation of the corrections of record in respect of 38 numbers of letters at an early date and correct the land records, bringing the land to the Khas KHAS status.
My land is at serial number 13, page 33.
The land of the petitioner is at serial number 13,
Page 33.
appended to the list. In the list appended to the letter public communication dated 16/7/1999, issued by the referred above. Full stop. Next, but it is noted that the facts of this case is similar to the facts on which this court had decided the case of Brindaban Chaudhary and another versus State of Assam and 6 others, WPC 4594 of 2020, decided on 9/2/2022. Most of the said petitioners' land are also covered by the list appended to the hearing before referred communication dated 16/7/1999, issued by the Commissioner Secretary to the Government of Assam, Revenue Department. Full stop. Next, by the said aforesaid order dated 9/2/2022, this court had held that had set aside the hearing before referred communication dated 16/7/1999,
16/9.
issued by the
16/9.
No, 16/7.
16/7.
It is written as, oh,
Where is that? You're reading from where?
page 61. Last line.
No, this is.
It is
It should be
16/7.
16/7.
16/7.
Typographical mistake.
16/7/1999. Issued by the Commissioner Secretary to the Government of Assam, from our Revenue Department, with a further direction that the respondent authorities shall proceed, shall make the settlement officer Bongaigaon should make an inquiry with regard to the claim of the petitioners on the basis of office memorandum dated 16/9/1988. And if the persons are found entitled on the basis of office memorandum dated 16/7/1988 or any other office memorandum, benefit be given to them. The operative paragraph 7 to 9 of the order dated 9/2/2022 passed in WPC 4594 of 2020 is extracted below. Next page. In terms of the aforesaid directions, as the petition is situated similar to the petitioners in WPC 4594 of 2020, this petition is allowed in terms of relief granted in the said WPC 4594 of 2020. By granting liberty to the petitioners to approach the concerned
Respondent number 4.
concerned respondent number 4. Who is number 4?
Deputy Commissioner,
I, the District Commissioner Bangaigaon, seeking mutation of their names on the basis of their on the basis of their documents. And the said authority shall deal with such application in terms of the observations which are made in the order dated 9/2/2022 passed in WPC 4594 of 2020. The business sense allowed to the extent as indicated above by setting aside and questioning of the next para, be it clarified hearing that as the communication dated 16/7/1999 issued by the Commissioner Secretary to the Government of Assam, Revenue Department has already been set aside. When order passed in WPC 4594 of 2020, then is the said communication already being set at naught NIU GST. No fresh order to the same effect is required.
Instead of respondent number 4, here will be respondent number 3.
3. Okay.
We are in
Deputy Commissioner, 4 is not an additional deputy.
31.
Item 31.
Respondent 1 to 5 has filed the affidavit.
Lordship, today I have filed my affidavit, Lordship. It's not on record, Lordship.
Okay.
It may be taken in the meantime, I shall file my reply.
Okay. How much time you need?
2 weeks.
2 weeks. Okay. Also as a represented is B. Sharma Ranet. CGC appearing for respondent numbers 1 to 5. submitted that she has filed an affidavit in opposition today, which is not a record. Full stop. This said affidavit will be brought on record. Sakti Upadhyay and counsel for the petitioner, respondent is granted 2 weeks time to file to obtain instructions and to file affidavit in reply, comma, if so advised. Next paragraph. List one, give a date after 2 weeks.
Lordship, I am appearing for 6 and 7, Lordship.
I said all of this. You want your.
2205.
Recording? SOP night.
2205.
Respondent number
6 and 7.
6 and 7 is present.
Item 33.
Wait, Your Lordships. This repetition has been filed for non-action on the part of the respondent number 2 for disposing of the petitions filed by the petitioner, Your Lordships, which is in Excer 20 page 144, filed under section 107 of CRPC, Your Lordships. The last applicant dishonorable court has, while issuing notice upon the respondent, Your Lordships, we took steps, Your Lordships.
You filed it before whom?
Before the Commissioner of Police, Kamru Metro, Your Lordships, filed under page 20.
Yes, you have got information.
Lordship, I have received some information, Lordship. And even then, Lordship, 107. This 107 has been executed by the executive magistrate, not by the my lord.
No.
No, one commissioner.
Once commissionerate is established, those ministerial powers go to the commissioner of police.
Oh. That instruction, my lord, that I have to wait, Lord, my lord, that I have received some instruction, on some of the cases that have already been FR, and some of the cases, my lord, the search sheet has been submitted.
No, in 107.
107, my lord.
In 107, there is no FR.
No, no FR, my lord, it was under process, my lord, that inquiry, my lord, that Assistant Commissioner of Police, Azara, is interested to inquire the matter, Lord. The dear Lordship, para 15, Lordship.
Where is your application under 107?
Oh, page 144, annexure 20.
144. We'll dismiss your writ petition. It's an abuse of the process of court. Now the question is how much cost? How much cost we should impose on the petitioner?
Because the reason, the reason why the petitioner has approached the.
You see, we don't expect that the police would inquire into the matter, rather we'll stop it. This is a matter where the police should not be directed to do anything. You want to grab the land, there is a suit against you. Then then in the proceeding of 145, you are an accused. There's an FIR filed against you for land grabbing, there you are an accused. You filed a suit where you are a defendant. And you did 107.
No, Lordships, the thing is not that there. I made some, has been lost, false FIR has been lost, but I have never been.
We'll stop all police investigation on any FIR lodged by you. We would invoke the extraordinary power to do extraordinary thing. Even if there's a genuine cause, the police will not investigate your FIR. Will curtail your fundamental right of lodging an FIR in any matter which involves the suit land.
But the report and the other, the
We will
report.
not permit that.
Lordship.
You are abusing the process of the report. How many FIRs are there against you?
2
or 3?
Maybe, your Lordship. One FIR that has been stayed by this honorable court. Another FIR, your Lordships, which is pending investigation, your Lordships. I made an accusation, but and the FIR which I've lost before this honorable court, the police authority has never.
Only 2 FIR against you or more?
Only, also, it more lost also only 2 FIRs, 1 FIR is
FIR.
Lordships.
There are 2 suits pending. In one suit, there is a counterclaim. You are one of the defendants in one of the suit.
The one suit has been kept in abeyance because the main suit which has been pending before the honorable court, wherein the counterclaim has been going on, your Lordship. Other suits are already, some of the suits has been disposed of, your Lordship. Disposed of, and one suit has been in favor of me, your Lordship. The suit has been compromised and.
Close that order. This is end of your good times. No point invoking any criminal court in respect of any affair which is connected with this suit land. You can only approach the civil court.
But on the day on 2023, I has been beaten up before the suit land when I was working at that suit land. That is why I approached the honorable before the police station for registering the affair. I was in hospitalized also. That is why I have filed this.
No sympathy. When you are accused in 2 FIRs.
No,
These
but
are
the one
145.
FIR that this honorable court has stayed.
When there is 145 proceeding going against you, we have no sympathy for you.
Lordships, if it is report, the report, your Lordship, the circle officer has been report, or ADC has been report has already been,
We will not permit it. Once there is a suit pending, you go over, whatever you want to agitate, you agitate before the civil court.
then I will withdraw the petition, Your Lordship. Withdraw the petition.
33 should be. There was a 34.
Uh,
24.
After some deliberations from Mr. H. Barwar and counsel for the petitioner,
35 to the
seeks to withdraw this writ petition. There is allowed. Matter since dismissed on withdrawal. Mr. G. Andy Clement, government advocate is present. You said your fundamental right. I would have taken it.
Lordship.
Your instructions are
Lordship,
back.
Item 34.
Court Lordship, they kept it in the record.
Not correct. Here we don't want to keep it here.
My lord, this is, my lord. Yes, my lord, non-consideration of my lord.
My lord, Mr. B. Gogo appears for this matter. Due to some personal difficulties, he has left the court, my lord. In the meantime, we will have our instructions, my lord.
Okay, if there's an interim order, we'll extend it.
No further action till the last.
Because normally he's here. Normally he's here.
Yes, please, my lord.
Dr. B.B. Todi, the senior counsel. Assisted with Dr. A. Todi, counsel for the petitioner. Due to some person, Mr.
H. Burwa, my lord.
H. Barwa, Learned Counsel, preparing on behalf of Mr. D. Gogoi, Learned Standing Counsel for the Finance within bracket Taxation Department. Raised for an adjournment. Prayer is considered and allowed. The interim order passed on 8/4/2024. Extended till the next date of listing. When do you want?
After 3 weeks, man.
Or 3 weeks? Yes? List after 3 weeks.
The lordship would give a fixed date, my lord.
Give a date after 3 weeks.
Must have been.
And you have less, my lord.
22/5. Timing item 24.
My lord, I'm the Anganwadi center, my lord. My Anganwadi center, my lord, have been established on 2003, and since then it is working, my lord. Recently, my lord.
Any reply from you? No. Social welfare?
No, one instruction I have received.
With this paper?
They do that, yeah. একে আছেন একে আছে Then Lordship, I need some time, Lordship. Only my lord, that extra copy was received on 5/1/24. So received the extra copy, we already been communicated lordships to the concerned authorities lordships on 6/1. We have not received my lord that up to date my lord instructions.
My lord, my humble prayer, my lord, further construction may be stayed, my lord, of that area, so that
Otherwise, it will left lordship and they will facing problem.
29.5. Item 35 for orders.
here is a note, my lord. Lord, there is a note from my lord honorable Registrar General of this honorable court, my lord, dated 30th April 24, my lord. There was a cost was imposed, my lord, of rupees 25,000, which was deposited, my lord, that is lying with the registry, my lord. So, but there is no specific order as to whom, my lord, that is required to be released, my lord. My lord. No, my lord. Review petition, my lord.
Then Raju Rai, my lord. Are bhai.
I mentioned item 48, my lord. There was a stay, my lord, till today. That will be extended. My lord, and date may be, date may.
Has kept it for today, Malas. Item number 43 and 44, Malas. Unfortunately, board could not fix by that time, Malas. Could it be fixed for 15, Malas, in that case? Yes, Malas. No, that is the Malas. We recollect that the issue of proposed arbitrator was there. If it suits my lords, Malas. 43 and 44, Malas, and there's a stay of the operation of the order, Malas. So very obliged, Malas. Deeply obliged.
About 46 interim order may be extended. Okay.
Yes.
Problem.